8th January 2026, the Jila Parishad may make immediate steps to cause demarcation of the land on which the road has been constructed by the Jila Parishad. This is the last order, my lord. If your lordship kindly take the order dated 5th December 2024, another order was passed by the Honorable Coordinate Bench. The same respect.
Jila Parishad.
Give us 2 weeks time, my lord. We will whatever, my lord.
Yes.
2 years have been lapsed.
The respondent authority is directed to comply order dated 8 January 2026 upon demarcation of the land in terms of the aforesaid order within a period of 2 weeks and submit report in terms of the said order. Parties shall be at liberty to mention after expiry of such period.
Grateful.
Grateful, lord.
Nay.
Item 2.
ये नहीं है चलो डिक्टेशन बेटा अपने आपने बोलो ये नहीं ऐसे सोमवार दिन ही तो दिए थे ना अपलोड करा था কি হয়েছে ভুল কি ও হাওড়া হয়ে গেছে This matter is appearing under the heading to be mentioned. Inadvertent typographical error has crept into order dated 15 June 2026 at page 3, paragraph number 8, line number 1, 2, 3, 4, 5, mentioning the words Treasury Officer Jalpaiguri 2, Howrah, instead of Treasury Officer Jalpaiguri 2. The words at page 3, paragraph 8, line 5th line shall be read as Treasury Officer Jalpaiguri 2 instead of Treasury Officer Jalpaiguri 2, Howrah. The aforesaid order is modified to the above extent. The other portions of the order shall remain unaltered. This order shall form part of order dated 15 June 2026.
Item 3.
My lord, I am for the petitioner, my lord. The petitioner has filed a
This
written
matter is
complaint. my
appearing
lord.
under the heading to be mentioned. Learned advocate for the petitioner submits that the petitioner does not intend to proceed. Where the written instruction?
Yes,
Want to withdraw this?
yes, my lord.
Private
The
correspondence.
grievance has been redressed, my lord. The concerned police
No,
station
okay, for the
has
petitioner
registered
submits
the
that
FIR,
the
my lord.
grievance of the petitioner has already been redressed, and as such, the petitioner does not intend to proceed further with the writ petition. He seeks for withdrawal of the writ petition.
But I am for the private respondents.
Learned advocate representing private respondent does not raise any objection. In view of the above, the writ petition being WPA 852 of 2026 stands dismissed as being withdrawn.
Grateful, my lord.
Lordship, in item number 4, I am appearing for the revenue authority. Lordship, this is my affidavit in opposition.
What is this? Can one is of?
Can 1 for filed by the writ petitioner.
Or?
Lordship, for CAN 1, I wanted the two parties to be added to the writ petition for proper adjudication of the matter. So Lordship, that is why we are seek leave. If I may be granted leave to amend the cause title for the addition of the parties.
Yes. What is your objection?
Lordship, the discretion of the honorable court, your lordship. They,
How they are necessary party?
Lordship, for the passing of the final demand order, it is required. for them to be heard.
Lordship, matter relating to TDS department, your lordship. Now there is a business of 3 or 4 states lotteries.
In which
They
paragraph you
want
have
to add,
stated?
your lordship, the Nagaland and other state lotteries agency. But your lordship, so far, my view, your lordship. It is not the-
Nagaland and Sikkim are related over here.
Lordship,
Naga-
as per revenue authority, that's not related. It is their business, your lordship. And here in West Bengal,
They are
TDS.
principal contracting parties to the agreement.
Lordship,
governing the lottery
it has to be decided who is the person responsible for paying. It's mentioned in para 6 of my CAN application.
business. Is a new question who can-
To decide the liability of this issue, that is why we need to add just these two respondents.
This is affidavit in opposition to the writ petition.
Lordship, main record.
Copy, sir.
Lordship, copies.
Copy has been given.
Today.
Can 1 of 2020 affidavit of service?
Lordship, I'll file in the due course of the day.
When you mention, why don't you check that the affidavit is ready or not? Can 1 of 2026 order to go to you again? This is an application seeking for addition of party namely Directorate of Nagaland State Lotteries and Directorate of number 1 Roman 1 crore, namely number 1 Directorate of Nagaland State Lotteries, number 2 Directorate of Sikkim State Lotteries. Mr. and so learned advocate appearing for the petitioner applicant submits that the Directorate of Nagaland State Lotteries and Directorate of Sikkim State Lotteries are the persons responsible for paying within the meaning of section 204 read with section 194B of the which act? Which act? Act. Income Tax Act 1961. And for effective adjudication of the issues related to the present writ petition, the presence of the aforesaid parties are necessary. She seeks for implement of the aforesaid parties as added respondent numbers 3 and 4.
Yes, your lordship.
3 and 4.
Yes, your lordship, 3 and 4.
3 and 4. The advocate undertakes to file affidavit of service in the course of the day. If it is fine, then change the affidavit of service. Later, Ajay Kumar Singhania, learned advocate representing the Income Tax Department. Income Tax Department does not raise any objection, but leaves the matter to the discretion of the court. In view of the contention raised, contention made in the application, it is found that the the aforesaid parties, namely number 1, 2, are necessary for the effective adjudication of the present writ petition, issues raised in the present writ petition. Accordingly, let Director of such and such and number 1 and 2 be added as respond numbers 3 and 4 in the present writ petition. Leave is granted to the learned advocate on record for the petitioner to implead the aforesaid parties in the cause title of the writ petition as added respondent numbers 3 and 4. Application being Can 1 of 2026 stands disposed of. Petitioner is directed to serve the copy of the writ petition and its annexures upon respondent number, added respondent numbers 3 and 4, and file affidavit of service on the returnable date. Read heading code WPA 2178 of 2024, affidavit in opposition. This is within time, Mr. Singhania.
Yes, Lordship.
Affidavit in opposition has been filed within time.
Lordship,
No,
affirm
no,
within time, your Lordship.
Affidavit in
March-
opposition filed
No,
on
no,
behalf of respondent number.
I think it is out of time.
Is taken on record, copy served, learned advocate for the petitioner.
Lordship, I want to
Application
file
affidavit
reply.
in reply.
They have filed the
Filed on
opposition
behalf
after
of
the
respondent
time
number
period
1.
mentioned in the order.
Let such affidavit in a reply be filed within a period of
4 weeks, your Lordship.
4 weeks from date. Parties, liberty is granted to the parties to mention after expiry of such period. File your affidavit of service.
Yes, your Lordship, I'll file in the due course of the day. Lordship, the same order for the next matter.
No, what is 1 and 2?
Lordship, yes, Lordship, in the item number 5, Can 1 filed by the revenue authority seeking leave to upload the order. Lordship, kindly appreciate the order, earlier order.
Lordship,
Lordship, in
this
earlier
can may
order
be taken up on
24th
Friday, your Lordship.
March.
Learned
Not
senior will
Friday.
be appearing
Then
for this
you
matter.
Take
Lordship-
it up before the next circuit.
Lo-
Not on
Lordship-
night.
Yes, your
No,
Lordship.
Lordship, that is the, Lordship,
Yes.
kindly appreciate my
Grateful,
submission
madam.
at first, Lordship. Lordship, in 24th March 2026, internal page, your Lordships, last 14 paragraph, your Lordships. Accordingly, the respondent authorities are permitted to proceed with the adjudication pursuant to the impugned show cause notice. However, no final order shall be passed without prior leave of this court.
Yes.
Lordship, if such leave is granted and the final order is passed, the same shall be remain in abeyance and shall not be given effect to in terms of the order of the Honorable Supreme Court and shall abide by the outcome of the special leave petition until further orders. Now, this writ petition, Lordship, assessment relating to financial year 2020, 19 and 20. Now, there is a limitation embargo, your Lordship. So, within 31st March 2026, the final order and assessment would be completed. Now, as per the Honorable Court's order, we have proceeded with the show cause notice and processing assessment is completed. So, we file this application within the March, your Lordships, for seeking leave to upload and publish the final assessment order, your Lordships. So, we need to seeking leave, your Lordship, before your, and I pray your Lordship.
My lord, my senior is here. He'll be addressing.
Appearing virtually.
Avram Mujumdar.
Sir, আছে?
Yes.
I'm appearing
Easy.
for the petitioner, my lord. My lord, we are objecting to the application we have made by the revenue, my lord, on the ground that, my lord, this is the leave cannot be granted by saying that the Supreme Court, the matter is still pending with the Supreme Court. And also the first, my lord, kindly see the order passed by the Honorable Justice Hiranmay
Yes.
Bhattacharya, my lord. There is no leave granted, my lord, only if the court thinks, then only if the leave can be granted. My lord, we have to make some further submission on this core, my lord. My lord, may I be permitted
No,
to
if
come
you
back
have
on
to, then
Friday
you
or
file your
after the...
opposition.
Yes, my lord.
You file your opposition to the application, whether
Yes,
leave can
ma'am.
be granted or not.
Yes, my lord.
Lordship.
My lord, kindly give us a direction so that we can file an objection to that.
Can 1 of 2026, your affidavit?
This is two.
Lordship, sir, but affidavit is not affirmed, but copy served, your Lordship.
Can 1 of 2026,
One and error, two.
this is an application seeking leave to upload the final order.
Lordships, assessment final order. In terms of paragraph order 14, your Lordship.
Leave. What, you have passed the final order?
No, Lordship,
My lord,
assessment.
they have to take the leave from the court. My lord, kindly see the order passed by the
Grant for
Honorable Justice
passing
Hiranmay Bhattacharya.
final order / publish and upload in the portal of the proceedings initiated under section 201 within bracket 1 / 201 within bracket 1 capital A of the Income Tax Act pertaining to financial year, this will be no, financial
Yes,
year
ma'am.
2019-2020 within
Yes, ma'am.
bracket assessment year 2020-2021 against TAN CALF 032540Z of the writ petitioner company. Mr.
How can you say?
Because we filed
Obro
on,
Mojumdar, learned
we filed on
advocate
16th April, they filed on
appearing for
16th.
the
हाँ,
petitioner, your opposite party, no?
कौन किया है?
Yes, madam.
कौन किया है? कौन किया है?
Future opposite party seeks to file. The petitioner opposite party seeks to file affidavit in opposition to the application.
Grateful, my lord.
Lordship,
Let such affidavit in opposition be filed within a period of 2 weeks. A reply, if any, be filed within a week thereof.
and
Party shall
Lordship,
be at liberty to.
Lordships, in this
mention
case, I am praying for extension of
Grateful, my
the
lord.
evidence in
Grateful, my lord.
opposition. There was a direction, Your Lordships.
And
also.
about one, you have any objection?
One, Your Lordships, I am I have the instruction to file an opposition, Your Lordship.
No, not one, two, sorry.
Two, Your Lordship.
In the
And
last
two,
matter,
Mr.
it was
Singhania
allowed. my lord.
seeks to file affidavit in opposition to the
Huh, wait,
application. Same direction.
In the last
Last
matter, it
matter.
was allowed.
For to add the
In the last
parties.
matter, the same addition of
But Your
Parties.
parties.
Lordship, there is a
Why is
limitations and
objecting?
other.
Only the financial year is different, my
Since
lord.
we objected,
Other are
okay.
same, my lord.
Same, absolutely
Your
same.
Lordship, but Your Lordships, I have the instruction in this matter to file an opposition.
Okay. Can two take similar direction? 2 weeks and 1 week to
Very
file reply? Let him file the opposition by
Lordship.
2 weeks. 1 week they will file their reply.
Lordship.
After 3 weeks you mention
Lordship,
after
Yes.
main writ petition opposition, Your Lordship, kindly
WPA,
extended, Your Lordship.
WPA 455 of 2026, Mr. Singhania, learned advocate for the respondent, seeks accommodation, extension
Extension.
of time to file affidavit in opposition. Similar, 2 weeks, 1 week.
Lords, grateful, Your Lordship.
Grateful, my lord.
चलो क्या नाम बोलो?
Lordship, for item number 6, I'm praying for restoration, Lordship, affidavit of service.
Your Lordship, item number 6 for estate, Your Lordship, learned senior AAG lead this matter, Your Lordship. This is for default, Your Lordship.
Dismissed for default, Your Lordship, I'm simply praying for restoration. Lordship, there was a resolution on that day. That is why I could not appear. Next, the resolution at page 8 of my CAN application. Page 4-5.
Okay, pass over. Ask him to come. Pass to.
My lord, I am for the petition in item number 7, my lord.
Your Lordship, this is DTA matter, learned AAG will appear shortly, Your Lordship. Kindly pass over.
My lord, in this.
GTA.
Yes,
My lord,
sir.
I am led by the learned advocate general. He is there, my lord.
ये शुरू होते बोलबे ना
My lord, may I proceed, my lord?
একটা কিছু brief দাও यार
Sir, yeah.
My lord, this petitioner was appointed as a
may I make one-
volunteer group D staff in a school situated within the jurisdiction of the Gorkhaland Territorial Administration, my lord.
Page number.
My lord, before your lordship takes up these matters, my lord,
My
may I-
appointment
Yes, Mr. Mitro,
My lord, I am
is at
appearing
page
for-
number 16, my lord.
just a minute. Yes,
My lord, in this bunch of matters, my lord, the state has to take a policy decision, my lord. I was praying for, my lord, a fortnight's time. I know the matters are pending, but kindly give me some time, my lord, so that I can take instructions and come back.
My lord, may I, my
this
lord?
was, well, Mr. Mitro, I asked Mr. Misra over here,
Yes, my lord.
that whether any report or any affidavit in opposition will be filed on behalf of the state authorities.
My lord,
Now, he
exactly,
says
my lord.
that
That is exactly what, my lord.
now,
the policy-
if you intend to take instruction, let that instruction be on record by way of a report in the form of affidavit or else affidavit in opposition against the writ petitions. So
They
that
will,
they
my
can
lord,
also counter and find out what are
Yes,
the
yes,
illegalities
definitely.
therein.
Definitely, definitely. My lord, in that event, kindly give me some time, my lord.
I
I
didn't
was,
come that day. I requested your lordships, let there be filing of the report.
Mr. Mitro was not there. I was, that is what I am saying, that I asked Mr.
Yes,
Misra.
yes, on that day, I still remember.
And
And for this case,
Mr. Mitro, you will be filing an affidavit in opposition to all the writ petitions and we'll
what
talk.
I was suggesting, subject to your lordship's kind considerations. Madam, this issue has already been decided by the minimum 20 to 30 coordinate bench. And appeal was preferred. 7-8 appeals have been disposed of, confirming the order of the single judge. So, show my lord, here nothing is, if there is a factual dispute, they can come with the report, no problem. But if there are the similar circumstances, I will be praying, my lord, that should not be any further. Because the binding precedent is, I have got the judgment. The coordinate bench is bound by the other coordinate bench as well as the division bench. If the issue has already been decided. If Mr. Mitro's client may have want to file a report regarding factual aspect, well, let it.
no.
Yes,
not
Mr.
only,
Mitro.
my lord, I was only humbly submitting, my lord, this stand of the state, my lord, has to be clear in this matter. My lord, that
Yes.
is why I was praying for a fortnight's time so that, my lord, I can take instruction and my lord come back. My lord, as far as I know, my lord, I was never there in these matters. As far as I know, my lord, there was initially, my lord, an order passed by a coordinate bench. Then, my lord, another bench, my lord, passed a different order. Appeals are pending possibly. Now I have to take instructions, my lord, about the stand of the state, my lord, which will take some
Then,
time.
Mr. Mitro,
one short.
I suppose it will be apt for you to file a report in the form of affidavit, at least to bring on record how distinct they are from the other writ petitioners who are similarly circumstanced, as Mr. Bari says.
My lord, if
Because until and unless you distinguish between these petitioners and the petitioners who are favored with the order of the Honorable Court.
yes, no, if my lord, this state, my lord, takes a completely different stand, my lord, then possibly, my lord, this situation would be different. So, my lord, kindly allow me to, my lord, take instructions on the stand of the state.
So you will
And
not be
that-
filing any report at this stage?
May I come with the instructions, my lord? Kindly keep it after a fortnight, and my lord, thereafter, if necessary, my lord, steps should be taken, my lord. That is my humble
That will be
submission.
delayed. That will be delayed. Because
They-
after
they have
fortnight, if
waited-
my lord, the further, if
They
it is
have
in opposition,
waited for some
let it
time,
be
my lord.
decided. Let it be
They-
decided.
They have
Mr.
waited for
Mitro,
some
whatever
time.
instruction that is given to you by the department, let it be on record so that it is also better for the court to decide. If you come after a fortnight, file a report in the form of affidavit and all the writ petitions, let it be on record. Or if you
Very well.
concede that they are similarly circumstances, a similar order can be
Yes.
passed, there is no question.
Yes, that is exactly
Right.
right, my lord.
So you come up
Well,
with the report in the form of affidavit.
In that event, kindly give me, my lord, 3 weeks time instead of a fortnight, because after, my lord, taking the instruction, I have to, my lord, take
Mr.
appropriate steps.
Surojit Nath Mitro, Lanet, Advocate General, appearing through virtual mode, submits that he needs some accommodation to take instructions. He seeks to file a report in the form of affidavit by the returnable date. Let such report in the form of affidavit be filed by the state respondents within a period of 3 weeks. Liberty is granted to the parties to mention after expiry of the aforementioned period. In all the other matters, the similar order is passed.
I think, my lord, yes.
Yes. The same order from 7 to 18.
Madam, we are giving the item number to your lordship.
There are some cases, my lord, appearing under motion also, not under the GTA heading.
But all are similarly situated.
হ্যাঁ সব বলে দেবো।
নাম্বারগুলো
Let,
দিয়ে দাও
let the report be filed in the GTA matters, which has been listed today. If you intend, if you can reach that, you can also mention. Yes, Mr. Mitro, so similar
Lordship.
direction is passed in 7 to 18.
Lordship, yes.
So in respect of other matters, my lord, which are not under the heading of GTA,
39 to 47 also same.
Those are new
We are
matters,
giving the
my lord.
number, my lord.
Kind-
Okay, give the numbers.
One
We'll
report
pass
will
out
be
it.
sufficient to decide the entire issue.
my
One
lord,
report.
in the other matters, which will be called in course of the time, in all likelihood, the learned advocate general might not be here, my lord, but we will be here, my lord.
Lordship,
11, 12.
Okay, thank you.
I'm deeply.
अधिकार आशा बोलवा.
84, 87 to,
7 to,
7 to 9.
because Mr. Bari, it is 7 to 18.
I'm giving
87
that.
to 98.
This is my lord, 8 থেকে শুরু হচ্ছে তো?
এটা কি? এটা বুঝে খুঁজে পাচ্ছি না। আমাদের লিস্টটা কোথায়?
আচ্ছা, আচ্ছা, আমাদের যেটা।
লিস্ট কোথায়?
8, 9,
Sir, you give your numbers
Yes, my lord, I'm giving.
and Mr. Bari, you give.
I'm giving that.
We will also give the names, my lord, of the advocates who are appearing. And in all the cases, my lord, we have been led by the learned advocates. Grateful, my lord.
Next.
দিয়ে দিচ্ছি, আমি নাম্বার লিখে দিচ্ছি।
সিরিয়াল নাম্বার গুলো পাশে দেওয়া আছে।
87 to 19 যা আছে।
এটা গোল করে দাও। হ্যাঁ। 87 to 98 আমাদের তো বলছি।
87 to 98
তারপরে আবার 100 যতগুলো তো এগুলো দেখে যাবে না। অনেকগুলো নিয়ে যাওয়া আছে।
Doc,
পরগুলো তো শুনি।
Hmm? 18 অব্দি তো বলে দিল।
87 to 98.
87 to 98 are similar matters, 84 then item number 100 lordship, all are similar matters, GTA matters.
But they have come under motion heading, my lord. I have marked it. হ্যাঁ ওর মধ্যে দিয়ে দিয়েছে, মার্ক করে দিয়েছে। ঠিক আছে। Obliged lordship. হ্যাঁ নাম্বারটা দিয়ে দিয়েছি।
Appearing under motion.
দেখতে হবে কত। হ্যাঁ এই যে এটা নিয়ে নাও তাহলে এটা না সেলাই করে নিবো অনেক থেকে, তাহলে এটা আমরা একবারে ঝামেলা মিটে যাবে।
I was thinking to appear, but as your lordship personally picks up the matter, I thought well, it is better to appear physically. Only for this reason I came today.
Anyway, thank you, Mr. Bari.
Get.
কালকে না কত ফোর্টনাইট টাইম নিল, এই দুটো তাহলে এখানে থাক, এটা থাকলো এখানে, এটা আমি দেখে আসি। একবার দেখে নিন অঙ্কিতা রায় আর ইএসআই।
এখন আপাতত
দেরি আছে
Item number 19.
19 will apply for the petitioners. Relating to refund of the overdone amount. It is well stated, so Lordship also directed.
When did you make payment? What is the date of retirement?
क्या दे रहे हैं
August, this is prior to the,
Yes, not bad.
wrong fixation. 5 years also no bar, was July to this. First, this goes. This is only 7,000 something.
No, Milord. On three occasion, Milord, total Milord 3,81,496. In paragraph 7, I have stated.
This is exceeds 5 years. As far as 16 is concerned, you will get refund. So far as 17 is concerned, there is no question of refund.
Milord, wrong pictures are overdone. And also, Milord, 15,
15,
page 15, overdone of prefix.
no, this is also prior to your retirement. You have retired on
Retired on
August.
Milord,
August 20.
31st August 2025.
Page 15 deposited on June 25, that is prior to your retirement.
Yes. June, July.
We cannot club it. Cannot be clubbed. If you have deposited in June 25, that is prior to your retirement, you cannot get the refund. I don't know what is the period. July 25, which you have deposited, that you can pay for refund. 3,60,000. 16 July 25, the period is less than 5 years. Only page 16
Yes. the page
you can
16.
trace for. What is the period in 15? What is the
15, there
period?
is no mention of the period. There is no mention, only Milord, indicated.
But this has been made within which period? The other clause is also there, no? This has to be within a period of 1 year.
My lords. My lords, I just received the report from them. So kindly give me one, not today. I will bring the report tomorrow and also.
Last house on the.
I know. Today was the day fixed for bringing the report. I have it in soft copy.
Who are due to retire within 1 year.
As per my instruction, my lords, she was an untrained teacher.
Yes. This is also within 1 year. I think you find out you will be entitled to refund in all the cases. Because these orders have been passed within 1 year of his retirement.
Yes.
Tomorrow,
Tomorrow, my
go
lords.
through your report.
Yes, my lords, tomorrow, my lords. Grateful.
কেন আপলোড হলো না?
হয়ে গেছে না খুলতে
Milord, I am Bhagwan. The matter related to interest on the gratuity. Only gratuity. No, sorry, interest on the aerial pension, sorry. Only aerial pension, not that.
Look, first PPO has not been annexed, my lord. He was retired at 21.
Yes.
And according to the revised PPO, my lord, he granted PPO on the
10
10th,
December
12th,
2020.
10th December. My lord, 2021 retirement date after 2019 ROPA. That document we have to date of 31/7/2021.
31st July 2021.
First PPO has not been annexed.
I have not annexed. As per the court order, yes. In supplemented, I will annex the. At that time, I have not annexed the order. It's not my knowledge. Yes.
Directing us to file a report, my lord. We need to file a report. এটা রিপোর্ট ফাইল করবেন, এটা অন্যরকম আছে, হ্যাঁ? 21 my lord, I appear for the case. But this is not an interest on gratuity case, my lord.
It's not interested. Mr. Jana is appearing.
I'll be needing some instructions, though, my lord, they have relied on two judgments, one by your lordship, one by Honorable Justice Mantha. But let Mr. Jana place his case, but I'll be needing some instructions at this matter.
My lord, I am for the petitioner. My lord, the husband of the petitioner was a census worker. My lord, the enumerator, my lord, the my lord, as per the state government notification, petitioner's husband being an census worker, my lord, he was considered an exempted category. My lord, the fact is that he participated at the selection process for primary teacher in the year 1999, and he was called for verification, my lord, in the year 2001. My lord, ultimately he was given appointment. My lord, joined on 3rd November 2003 and retired 31st August 2012. My lord, as per DCRB scheme, My lord, this shortfall 1 year, 2 months, 2 days. My lord,
2 years.
I prayed for only condonation of the shortfall of service 1 year, 2 days, 2 months, 2 days. My lord, on the and for grant of family pension, she made a representation that is 29 May 2026. Your lordship, my lord, the minor also, my lord, delivered a judgment, your lordship, 39. This is the wrongful action on the part of the state authority. Your lordship, signed my call letter, my lord, the annexure 3, page 24. Call letter, my lord, for interview
2001.
1, but ultimately she was given appointment in 2003.
3.
That is the fault of the state. That is why, my lord, the shortfall of my service, my lord, for family pay qualifying service.
Okay, affidavit of service filed on behalf of the petitioner is taken on record. By the present writ petition, the petitioner seeks direction upon the respondent authorities, particularly respond number 2 and 3, to consider the prayer of the petitioner for family pension in connection with service of her late husband, who was an assistant teacher of a primary school under Kuch Bihar District Primary School Council. The petitioner contains that her husband, late Jitendranath Bormon, was an assistant teacher of Fulbari Junior Basic School under Mathabanga 4th Circle, District Kuch Bihar. The petitioner's husband retired from service on superannuation on 31st August 2012. However, no pension was granted since there was a shortfall of 12.
When
did he die?
Died, my lord.
When did the
No, he was appointed on.
when did the husband die?
Die.
20th March
Hello.
2019.
28 March 2019.
In which paragraph you have stated?
Page 33,
Page
I have
33.
death certificate. Page 33.
However, no pension was granted to the husband of the petitioner due to shortfall of service of 1 year, 2 months, and 2 days.
Yes.
The shortfall in service is precisely attributed to the state and not to the petitioner. The petitioner's husband, who expired on 31st March
20th March.
28th March
20.
20.
Page 33, my lord.
20th March
2019.
2019. Page 33.
Page 33.
Yes.
12 रिटायर कर 20th মার্চে মারা যাচ্ছে 12 সালে রিটায়ার on where is your representation? On
Representation.
29 May
34.
2026, petitioner made a representation before the authority concerned seeking for grant of pension. However, the same has not been considered as yet. Hence this writ petition. Mr. Kunalji Bhattacharya, learned additional government leader, seeks to file a report. Seeks to file a report.
In the form of an affidavit.
In the form of affidavit. Let such report in the form of affidavit be filed within a period of
3 weeks.
3 weeks. Parties is granted liberty to, exception if any be filed within a week thereof. Parties have liberty to mention after expiry of such period.
Lord, may I submit one thing, my lord? probably, my lord, my learned friend for the state will not object, my lord, this application may be considered and pass it in order. My
No.
lord, that will be, we do.
My lord, in this case, because the,
File your report.
yes, grateful, my lord. Great.
22, my lord, and for the petitioner. My lord, this matter is pertaining to the overdrawn.
That overall matter, my lord, we have to take instruction, my lord.
My lord, we have
3 lakh.
already paid the deposited amount in two parts. Lordship kindly sees that the first deposited amount was made in 18th of June 2024, Lordship, and the second part was made in 26th of November 2024. We have annexed the challan also, Lordship.
Lord, kindly make one day accommodation so that we can verify, my lord, with the challan.
When did you retire?
I retired on 31st of March 2024, Lordship. It's in paragraph number 3, Lordship. Page 3, paragraph number 3.
March 24, November 24. This is June 24. Pension payment order issued on?
Payment order, Lordship, issued on 20th of February 2025.
না নাম তো একই আছে যে কমল কা ভাই তিন বিদ্যা 3 নম্বর আলাদা
ঠিক আছে You take instruction.
hello one day minute tomorrow I
All is after the retirement.
come
Yes.
what do minute
You will not put your more.
Lordship.
Twenty-three.
23, Lordship, this is for gratuity and arrears under ROPA 2009, Lordship. There
Sir,
was
he
a
is an employee
yesterday,
of Kujbihar Jilla Porishad, my lord. He can file a petition before the honorable court, my lord. And the 2009 is effect from 2006, my lord. This is a retrospective effect, my lord. I have the notification, my lord. No, I got, I believe.
The petitioner contains that affidavit of service that he was an employee of
petitioner was an employee
Office
in the
of
office of
Kujbihar
Kujbihar
Jilla
Jilla
Parishad,
Porishad.
District Kujbihar. The petitioner retired from service on superannuation on
31st of December
31st December
2006, Lordship.
2006. The pension payment, first pension payment order was issued on 27th February
February
2008.
Lordship.
The revised pension payment order under ROPA 2009 was issued on
6th of February 2012.
12. The revised gratuity and aided pension amount was disbursed on 15th April 2012. However, no interest was paid, hence this writ petition. $14 years. $14 years.
14 million.
After court prompted you to file an application after 14 years. Hmm?
अभी तो चल रहा है 22 চলছে তো দাদা এটা 22 চলছে তো
কি বলো
23 চলছে 22 তো টাইম নেই ইনস্ট্রাকশন নিয়ে ওভার চলছে
our submission same delay clause টা দেখ effect of what is the date of effect of ROPA 2009 Mr. Ghosh
20 yes your lordship
Hmm?
it effect from January 2006 lordship. Don't take
কি আছে
23 sorry
সুপ্রিম কোর্টে কি জানেন দেখি First January 2006 এটা একটা দিয়েছে চেক করে নেবেন আচ্ছা যেটা একটা ফাইন্ড আউট করুন 2009 এ কি আছে disposed of
grateful lordship
24.
24 lordship it's for the gratuity in areas on single PPO lordship. The petitioner was retired on 30th of November 2024. In paragraph number 2 lordship, he was an assistant teacher in Raja Rammohan Roy High School, Ulbazar district, Darjeeling.
affidavit service filed on behalf of the petitioner is taken on record by the present writ petition. The petitioner seeks direction upon the respondent authorities for disbursement of interest on delayed payment of gratuity and arrear 18% from the date of following the date of retirement till the date of actual payment. Petitioner contains that he was an assistant teacher of
Raja Rammohan Roy School.
Raja Rammohan Roy High School, post Ulbazar district, Darjeeling. The petitioner retired from service on superannuation on 30th November 2024. Pension payment order was issued on
10th of March 2025.
disbursement 12th April 2024. Sorry, 2025.
25 lordship.
No interest was paid. Rest same.
get to Registered 2006 appearance madam registered appearance for the
Next.
25.
Similar lordship. Single PPO gratuity in arrear.
State is represented, your lordship.
Paragraph 2 lordship, he was an assistant teacher of Railing High School, post Railing district, Darjeeling. He was retired on 30th of September
The
2024.
affidavit of service filed on behalf of the petitioner is taken on writ. Name of the school, assistant teacher of Railing High School, post Railing district, Darjeeling. Date of retirement 30th September 2024. Pension payment order
10th of January
10 January
2025.
2025. Disbursement on 15 January 2025. No interest. Same order 6 weeks.
Great, your lordship.
26.
Similar lordship, single PPO gratuity in arrear. Petitioner was retired. She was retired on 30th of March 2024.
May 20.
She was assistant teacher in Kameshi Primary School, Kalimpong district, Darjeeling.
Kameshi Primary School, post Kalimpong district, Darjeeling. They retired from service 30th April 2024. Pension payment order 21st May 2025. Disbursement on 12th July 2025. The rest same, 8%.
Similar lordship, single PPO gratuity in area. Gratuity area lordship, he was assistant in Rangli Gram Panchayat, Tagda, District Darjeeling. Paragraph number 2, lordship.
Executive assistant of Rangli Pit Gram Panchayat, post Tagda district, Darjeeling. Retired from service on 29th February 2024. Pension payment order 14th November 24. When did you receive that?
27th of December 2024.
27 December 24. এখানে executive assistant panchayat, paragraph 2.
Assistant, executive assistant.
Rest same. Affidavit.
পঞ্চায়েতে পড়েছেন
Similar lordship on single PPO gratuity in area. Petitioner was posted at Panchayat Kurmi of
Shoreni 2 Gram Panchayat.
Shoreni District Darjeeling. Paragraph 2. He retired on 30th of June 2023, lordship.
Panchayat Karmi of Soreni 2 Gram Panchayat, post Soreni district, Darjeeling. Date of retirement 30th June 2023. PPO issued on
PPO issued on
18th
18th of
March.
March
18th March
2024.
24. Amount. This is gratuity
Disbursed on 17th of
17th April
April
2024.
2024.
Rest same.
Gratefully, lordship.
29.
Similar lordships, single PPO gratuity in area. Yes.
29 the time for the petitioner, the interest on gratuity and area pension. Both. Single PPO.
Head teacher.
For teacher of a
Nutan Bas, CS Primary School, District Kuch Bihar. Retired from service on superannuation 31st December 2023. Pension payment order issued on 4th September 25. Only gratuity or
gratuity and area pension. Both.
gratuity and area pension disbursed on 16th September 25. I want no interest was paid. Rest same.
Lordship also single PPO gratuity in area, lordship. Petitioner was the assistant teacher of Jaldhaka Higher Secondary School, Jaldhaka District, Darjeeling.
Assistant teacher.
Assistant teacher, lordship. Jaldhaka Higher Secondary School.
Jaldhaka Higher Secondary School, post Jaldhaka District, Darjeeling. Date of retirement 31st December 2024. PPO 17 June 25. 11th August 2025 disbursement. No interest same. Okay.
Similar lordship on single PPO gratuity and area. Petitioner. Assistant teacher of Nepali Kollan Girls High School, District Shiliguri. He retired on 31st of August 2022.
Wait. Group D, employee,
Yes. Paragraph 2, lordship. Assistant teacher
assistant teacher.
of Nepali Kollan, page 3.
For these students, you say she was appointed as group D.
No, lordship is a assistant teacher, lordship. Kindly.
31. Olika Sharma.
Alika Sharma,
Yes, Lordship.
Alika Sharma. Lordship
assistant
is a-
teacher or group D.
No, lordship. Lordship, kindly see the PPO.
Last post here, group D.
Yes,
And
lordship.
in page 3, you say she was an assistant
No,
teacher.
lordship. The PPO has it says that it's group D.
Then why do you say she was an assistant teacher?
Lordship, it's a mistake for draft, the part of drafting, lordship. Lordship,
Who
kindly make
drafted?
it a note today, lordship.
Why?
Lordship, it's PPO has been shown, lordship. It's a part of the drafting mistake, lordship. It's a group D.
Make a group D assistant teacher.
No, lordship. Lordship, pardon, lordship. This is pardon, lordship.
Figure of learned advocate for the petitioner leave is granted to correct
lordship.
the designation of the petitioner in the first line at page 3 of the writ petition. You correct it as group D.
Yes. Lordship, the PPO issued as a group D stuff, so. Here.
Group D of Nepali Kalyan Girls High School, post Pandhan District, Siliguri. Pension payment order was
Your
issued-
Lordship, it should be District Darjeeling.
District Darjeeling.
Yes, Your Lordship, because Shiliguri is not
Shiliguri
a
is not a district,
district, Your Lordship. The first
Then
paragraph
this
of page.
post
Yes, even
Pandhan,
the cost item.
this is
also.
correct.
No, Lordship, District Darjeeling, the cost, it should be corrected by me,
Page
Lordship.
3, my lord is asking about page 3, first paragraph regarding the post office.
Even
Post, yes, post Pandhan, this is correct.
Lordship, I have
Puro
to
check
check,
it.
Lordship.
Not today, check it.
Yes, Lordship.
Tomorrow we'll take it up, we'll
Great.
check it and then correct it.
Grateful, Lordship.
Check whether the post is correct or not, address is correct or not tomorrow.
Grateful, Your Lordship.
Next.
32, Lordship, similar, single PPO graduation area, Lordship. Petitioner was an assistant teacher. He was retired on 29th of February 2024.
Teacher of Atingtar Primary School, post Lodhoma District, Darjeeling, retired on 29th February 24. PPO issued on 26th September 24. Disbursed 11th October 2024. The rest same. Give the affidavit of service.
Grateful, my lord.
Grateful, Lordship.
33.
33, Lordship, single PPO graduation area, Lordship, petitioner. Petitioner was appointed as an assistant teacher in Rangapani Balushi 5th Plan Primary School, Lordship.
Was an E. You can delay clause to the 2008 assistant teacher Rangabani Balasi 5th Plan Primary School, District Coach, Bihar. Retired on 30th November 2008. 8. Pension
2008.
payment order. Pension payment order 10 September 2010. Gratuity and area pension 20th September 2010. Delay clause to the other. Next.
34, my lord, this matter is pertaining to the overdrawn lordship. Petitioner has retired from this service on 21st of March 2025. Was appointed as an assistant teacher
Your lordship,
based on
prior my learned colleagues makes her submission, your lordship, in this matter, in the representation form, it was ought to appear on 19th, your lordship. In the letterhead, she has mentioned it would be appearing on 19th. So we have asked for the instruction. It is pertaining to overdraw, your lordship. So we require instructions before making our submissions, your lordship. So kindly keep it on 19th, your lordship.
tomorrow.
We are asked for. My lordship to that kind of. It was ought to appear on 19th, your lordship. So we have also
Why
prayed
did you-
for. This is the letterhead, your lordship. So we have also asked for the instruction, but we are yet to receive it, your lordship. So kindly keep this matter on 19th.
But
your
presentation form show as 17th.
lordship. But while serving it, because we have received it yesterday, your lordship.
Will the report by tomorrow, making it not
Yes,
today?
kind of.
We have already asked for it, your lordship, but we are yet to get it. So we will try. My lord,
Tomorrow?
kindly keep this matter
Tomorrow.
tomorrow. Grateful, your lordship.
Not today.
Yes,
35.
35 also overdrawn. It's pertaining to the overdrawn, my lord.
My lord,
Depot
some time is
service.
required for instruction, my lord.
Same matter. Petitioner deposited the overdrawn, my lord, on 2nd of March 2022. The annexed challan, lordship, it's in page number 16.
By the present writ petition, the petitioner seeks for a refund of alleged overdrawal of salary. Honorary advocate for the petitioner seeks accommodation to file report. Let such report be filed within a period of 2 weeks. Liberty is granted to the parties to mention after expiry of such period. Next.
This also, my lord, pertaining to the overdrawn, my lord. Petitioner has already deposited the amount on 28th of September 2023, lordship. She was retired on 31st of
It was served yesterday,
March
my lord. We have
2023.
sent it, instruction, my lord, kindly, my lord, supposed to become 19th, my lord.
Lordship, kindly keep it on tomorrow, lordship.
Get report by tomorrow.
I'll try.
We'll make it. Not today. Next.
Get a phone, you know.
Lordship, the Passover item number 6 by learned seniors.
Your lordship, this is for restoration, this is for default, your lordship. Up to your discretion, your lordship.
Can 1 of 2026, this is an application seeking the item number 6.
Your lordship.
This is an application seeking for the restoration of the petition upon recalling order dated 27th April 2026. 27th April 2026. What is the reason?
Lordship, there was a resolution by the bar.
Where have you stated?
Lordship, I've stated in my annexed A, page number 8.
8.
8, page 8, your lordship. For that reason, I couldn't appear physically and the matter was dismissed for default.
Learned advocate, Ms. Soito, learned advocate for the petitioner submits that on the date the matter was taken up, that is 27th April 2026, there was a resolution of the bar for which reason the learned counsel did not appear since and at the same time the learned counsel was ill, which has resulted in dismissal of the writ petition. The application seeking for restoration is filed within time. He seeks for the restoration of the writ petition upon recalling order of dismissal. Learned advocate for the state leaves the matter to the discretion of the court. It is found from the contention of the application that the cause shown is sufficient to restore the writ petition. Accordingly, the order of dismissal dated 27th April 2026 is recalled. The writ petition being WPA 620 of 2026 is restored to its original file and number. Application being CAN of 2026 stands disposed of.
Yes, can.
Will filing any report or any opposition?
Yes, that's it. Report opposition.
GST matter.
Yes,
GST matter. Let it be kept tomorrow, my lords. It has been restored today. We will keep it tomorrow. Because other GST matters are also there tomorrow.
That will take time. The other matters he is arguing.
No. Everything has to go to the tribunal.
Chief, I'm
That is your
challenging the
contention.
adjudication order. here.
And it doesn't matter. Everything has to go to the tribunal. Tomorrow.
Yes.
I'm obliged.
So affidavit
Tomorrow.
of service for the CAN
The
application.
other matter you filed the affidavit?
I'm bringing them.
It is needing affidavit of service.
Grateful.
Disposed.
But in this matter, all I could gather is he's simply wanting to expedite his appeal that is pending before the SIR appellate authority.
Let me submit, my lord.
Your Lordship, I
And we are
appear for the
making-
Election
that may be
Commission of
allowed.
India. Similar orders have been passed by the coordinate bench. My junior is carrying the order. Similar order could be passed, Your Lordship.
Yes.
My lord, I am grateful to my learned senior that they are allowing for expedite hearing, but the issue needs further police clearance certificate. That's the interim order which we are seeking more about. If I be allowed to submit, I
Sir,
will.
until and unless your SIR is clear, the police clearance certificate will not come.
That my lord will just
So that
decide.
will step by step.
That I will explain that cannot be withheld just because SIR is pending.
Yes.
My lord, kindly comes to page number 47. This is the recruitment notification in Indian Army. in which I have been selected. And further on, my lord, on page number 55, the documents which are required to comply with this recruitment. My lord, in page number 55, point number G, serial number, there is a document, police character certificate. Here it's written police character certificate issued within last 6 months. That was, my lord, required in the very first step. My lord, that was kindly come to page number 68, my lord. This is the page number 68 mentions what is the PCC certificate is about. It's from the website, official website of the police clearance certificate where everyone applies. Here is clearly mentioned police clearance certificate is an official document issued by police or government agency of a country to certify that an individual has no criminal record and has not been involved in any criminal activity. It's exclusively for criminal activity. My lord, further on,
But this does not apply in your case.
Yes, my lord, that's I am coming to. In the first instance, finally come to page number 64. It happened during the 2000. 64, my lord.
67.
Should I come 67? Yes, my lord.
The applicants who do not possess Aadhaar card may apply for police clearance certificate.
I do possess Aadhaar.
You possess Aadhaar.
Yes.
That's why I say that you do not have to get a police clearance certificate since you have a Aadhaar card.
No, my lord.
That is what 67 says.
There it is saying that we can get it through police station or police district office.
Sir, read the sentence. The applicants who do not possess Aadhaar card may apply for a police clearance certificate.
Yes.
Since you say that you have Aadhaar card, so in your case, police clearance certificate is not required.
No, my lord. For my army recruitment rally, it's clearly mentioned that I have to procure a police clearance certificate. And this is a website where it is depicted in the website that those do not have Aadhaar because they can't log in there without OTP. That's why it's just a disclaimer that they can then approach the local police station and get it through offline mode. But police clearance certificate is my criminal antecedents, which was I also granted, my lord. Kindly comes to page number 64.
55 is the
page number 64. There on 15th of November 2025.
No, this police character certificate and clearance certificate are same.
Yes, it actually shows my character. No criminal antecedents. The name of the certificate is police clearance certificate.
It's 64.
Yes, my lord.
Police clearance certificate.
Yes, my lord. That was granted to me. Okay. Further on, successfully I completed the rally and all the other steps as per the admit card, as per the provision of the army recruitment scheme. And on page number 62, I have the admit card of the same. Page number 62. My lord, in Agniveer scheme, we always must produce PCC certificate before we can even participate on race rally. So after that, I got this admit card, and on page number 63, there is a result, my lord. Once I completed the written examination successfully, there is my roll number mentioned in the middle portion, 15th row. I am been selected.
Just show me.
Yes, my lord. So after that, my lord, successfully, what happened?
Where is your roll number?
My roll number is, my lord, 106512. It's in the middle of the
106.
Yeah, last 106452 in the middle portion, my lord. It's the website.
106452.
Yes. Kolkata, West Siliguri, AVGD 2025 106452. This is in my admit card, my lord. So I successfully completed all the stages.
Okay.
Further on, my lord, kindly comes to page number 65. Because further on, what happened is that Army AR office contacted me. Those I have annexed, but meanwhile, they have instructed me to produce because this PCC was expired on 6 months. The previous one, which is annexed in 64, there is clearly mentioned this is only valid for 6 months.
Page number 63 that you have just shown. If I compare it with page number 62, the roll number there in page number 62 must appear to be ending with 106512.
Yes, here it is 106512. In the middle, 106512. I am being selected. Please see 106512.
Yes.
Oh, eligible.
Yeah, because for security reason, my lord, it's army recruitment. They produce it in such a way that even downloaded portion, machine not readable. So that's the reason. My lord, what happened is that further on, I have to apply for the new PCC because in order to join finally, I have to produce a valid PCC. My lord, kindly come to page number 65.
Yes.
This is my June. Meanwhile, what happened, my lord? On March, my name got deleted in SIR. Before that, that was not the case. And this time, on page number 65, this was my application because I had to report to my headquarters. Police kept holding it. My lord, 69 page number. I visited several times. I mailed them. Page number 76. 69 is a record I visited. It's just a demo. I visited there. They kept me waiting day and night. Page number 76, my lord, I mailed to the higher authority that why is my PCC being not cleared? Previously, it was issued within 2 days, my lord. It's an online process. And just last 6 months, I was given it.
What is your age?
20 years, my lord.
20.
20 years. So, my lord, all they kept saying is that because your name is deleted, we cannot give it to you now.
It is
Go.
deleted or your name did not appear?
My name is deleted in SI process. That is also pending, my lord. I will now come.
Previous voters card?
Yes, my lord. Kindly, my lord, come to page number 24. My and my father name been deleted. That is the main reason they are holding my PCC certificate. Page number 24 is the appeal against which there is my epic number mentioned my name, and it is the appeal pending at tribunal. And page number 29.
24 is your appeal, yes.
Yes, my lord. And page number 29 is my father's appeal.
This was deleted for which reason?
Linkage with father, my lord. The reason is that my father got his voter registered only on 2023. My lord, kindly comes to page number 37. There's my father's epic number. Because my father's got deleted, I also deleted. And they had set the deadline of 2002 roll. So page number 37, there's a 2003 when my father got this voter card for the first
39.
time. So he could not be, but his father's is there in the 2002 roll. Kindly come to page number 42, my lord.
Your
My grandfather and grandmother, both voter card I have annexed on page number 40 and 41.
The 39 is the voter card of?
My father, my lord. My father name is Farooq Sarkar.
The 39 is Fuljan Khatun.
Sorry, page number 37. Page number 37 is my father's epic.
Farooq.
Yes. This voter and my voter is deleted. And here it was only on 2003 he got it. He couldn't be in 2002 roll. But that's fine, my lord. My grandfather was there, so he should not to have been deleted. Irrespective of that, I have my lord.
42.
Yeah, page number 40 and 41 is the election voter card of my grandfather and grandmother, from which the lineage comes forward, 40 and 41. And they can be seen in page number 42, the roll, official roll of 2002. Their name is there.
Okay.
The grandfather's name and grandmother's name.
374 and 377.
Yes, my lord. They both are present in 2000 roll and they have not been deleted. They have also voted in 2026. My appeal is pending, my lord. Irrespective of that, I am relying upon the Supreme Court judgment in ADR versus ECI, which is the conclusive judgment in this regard, in this kind of situation. My lord, this is the conclusive up to what extent SIR can be interpreted. My lord, please comes to page number, paragraph number 171 of the judgment. Here it is clearly mentioned, it must, 171 of the, page number 114 of the judgment, 171 para. Throughout numerous para, my lord, it has been reiterated that citizenship can only be up to the extent of voting rights.
Sir, where is the other pages of the judgment? Where is the other pages of the judgment?
My lord, I have, because it was a voluminous judgment, I've just, the last where the orders were given. My lord, please comes to, I'm giving,
We do not know what happened in paragraph 1 to 117.
my lord, I'm guiding. My lord, please comes to page 120 of this Supreme Court's. Here the conclusion direction. It's continuous, my lord. Page number 120.
Yes.
Yes, my lord. Here 186F. 186F, it reads, the commission is empowered in the exercise of its constitutional mandate to undertake a limited inquiry into citizenship for the purpose of satisfying itself as to eligibility for inclusion in the electoral roll. Such an inquiry does not amount to determination of citizenship in strict sense, and any action taken pursuant thereto is confined to electoral consequence alone. My lord,
Which clause?
page number 1, it's even further on. The conclusively, the Supreme
See,
Court. Yes, my lord.
Which conclusion you're reading?
F, page number 122, F. No, my lord, G. Apologies, my lord. F and G, all of them points that electoral has to be, it's only for voting rights. G says in case where commission is not satisfied that a person meets the statutory condition for inclusion in the electoral roll, it would be incumbent upon it to refer with such individual to competent authority within central government. This SIR cannot determine my citizenship. They have to refer it to competent authority, and here my appeal is also pending in tribunal.
Your Lordship,
F and
ECI
G,
in
my
terms of
lord.
Supreme Court's order is referring matters which they have found that they are not proper citizen to the concerned FRO
Madam, you wait.
department.
You wait for some time. You wait for some time. Let him complete.
My lord, so my submission is that this judgment clearly in point number F and G conclusively says that it's not a determination of my citizenship. Moreover, my issue is still pending at tribunal. That can also still be challenged in High Court.
Yes.
Further on, my lord, I am relying upon the framework Supreme Court order regarding in the Mostaru Banu case. Sir. My lord, here also, the Supreme Court actually created this SIR under the framework of Mostaru Banu. This order actually dictates how such and such matter relegates the petitioner to approach High Court. Here in the second line, the Supreme Court says, however, we understand that some issue will continue to arise on day-to-day basis, which may require the urgent attention of either the Honorable Chief Justice of the Calcutta High Court or Appellate Tribunal. The Supreme Court recognized urgent attention would be required, and here in part 2 of 1, it states that similarly, if the matter requires judicial intervention, they shall be entitled to approach High Court on the judicial side. So it's under this framework, I have approached the High Court. And my lord, my only prayer is that first of all, irrespective of my SIR status, I should not be denied PCC, first on the based upon this judgment. And also the PCC is only for my police clearance record. If I had been given such record in November, and what has changed other than my SIR? And they have been explicitly saying, even the ECI just, and also my learned senior argued that without SIR, you cannot be given. So SIR cannot withstand my PCC clearance. Second, my lord, I am also coming, please see the page number 73 of the petition, my lord. Annexure, page number 73. This was another such case where the deletion had happened, page number 73. It was the 6th of April 2026 when the nomination filing date was the deadline date. And there also Supreme Court gave time-barred direction to the tribunal to decide by the afternoon of 6th so that the person can file his nomination in the Vidhan Sabha. So, my lord, this I am referring because the court possesses enough power to direct to first restore. Why I am also seeking restoration, my lord, because it's ambiguous. The states and unions
Restoration cannot be done by the
No,
court.
I'm not seeking restoration. Restoration in front of tribunal. This direction was also to go in front of the tribunal, and tribunal was directed to decide on merit. So I am only seeking merit.
That appeal you have filed, the tribunal will decide.
Yeah, but that time bad because my lord, even if my police clarification is being withheld, again when I go to army, there will be internal records, and again state, home ministry and everyone is referring me as an suspect with regard to citizenship. My lord, only way I can completely cohesively come out of it if my appeal is decided on urgent basis, which they have already said this, that can be done. My lord, apart from that, the interim protection I need is, irrespective of the outcome or when the tribunal decides my case, my PCC should not be withheld if there is no merit. If I have any criminal antecedents or any other thing, that's fine. But only based on SIR, it should not be held upon, because my job is at the stake, my lord. I have cleared all the parts. And in November also they gave, this is the status report, because the update, why they have deleted what they have provided. This is the downloaded result of that application, my lord. Is the website, in the website when I have applied, the first one is approved by the authority. The second one is rejected. The one which I have annexed, it was yesterday rejected. Further on again, I have applied. It's now payment done. It's been pending, my lord. They will not process my record until the SIR clears my name. But that's a lengthy process. It will go to tribunal. I have to face that. I am also ready to.
It is not a lengthy process. Within a week, the SIR appeals have been disposed of when
Week,
the
my
orders
lord,
are
I
passed
don't
by.
have week. I have to report on 21st. And okay,
Your
my lord,
lordship has
if it,
approached the
even
court
week,
late.
that's fine. But my PCC, if gets cleared, I'm relieved. Only main relief I'm seeking is my police clearation cannot be withheld. That's my submission, my lord.
Your lordship, in his case, when the authorities have deleted his name, the question whether he's a citizen or not has also been reported to the FRRO from the Election Commission office in terms of the Supreme Court's order. So, your lordship, kindly do not pass any other. The usual order passed by the other benches of the Honorable High Court is that the tribunal is requested to expeditiously dispose of the matter. My junior is carrying that order. She will hand it over. Miss Madhusri is there.
My lord, Supreme Court has conclusively decided, yes, that
Please. Yes, that is all.
On behalf of the state nurse, in the beginning itself, I have considered that something that is wanting, that is something that can be done. That is regularly done. I have a little bit of minor exception, the way the case has been put up and the way the judgment has been shown. Here in this High Court, Milords, we do not show tailored judgment. What the problem here, Milords, is with regard to PCC, if I can have my lordship for a moment on a previously PCC that has been issued to him, he is page 69. Okay. And we do not use okay and things like that also while referring to the honorable justices. That is also another thing.
apology.
Page 64 Milords for a moment.
64.
The 64 is written like 69. Anyways, in a police clearance certificate, Milords, the PCC that is issued, it is certified from the record, verified from such and such date to such and such date, and I will come to the period that he is asking for, of the Pundibari police station, Mr. and Miss such and such, whose Aadhaar card number is such and such, and his son and daughter of such and such. Now, this is a peculiar case because not only his SIR is under doubt herein, his father SIR is also under doubt herein. Now, obviously, if a person recognition as on today has to be given, that would be the name of the person followed by the name of his father that is there. In his case, both of that is under adjudication right now. So that, Milords, is the real issue why a PCC in the present form, Milords, cannot be issued to him based upon his application. The relevant page whereof is page 66 because he is asking from 2021 till 2026. At page 66, Milords will find that.
Which is the period? No?
Yes, Milords. Period of stay at the present address, month is January 2021, and he is asking till May 2026. Generally, it is for 5 years. So whatever it is there, Milords. That will be given to him, but it has to happen in seriatim. Unless the SIR is not clear, then Milords, this probably cannot be given in the present form that he is asking for, number one. Number two, in all these matters, what happens most, I could have taken a technical objection, why 226, he should go to 227 because it is a tribunal that is there, but I am not going into all this. He is a prospective candidate for a Agni recruitment process, my lords. All I would say is that based upon the usual order that is passed, let an order be passed before the tribunal to expedite his hearing. Let his hearing happen expeditiously. If he is able to cross that toll gate in the hearing at the tribunal, then the police authorities will do the needful. That is all that we have to say, and that is what we submitted at the very first occasion, first off, without him even presenting his case.
So how long you will take?
Because generally the tribunal, if there is an order by the High Court, the tribunal doesn't take more than 7 days. There are more than
Your
7 or
Lordship,
8 lakh
today-
cases pending.
Today itself, I'll forward his application, his writ petition along with the order.
We will do that.
So
We are
that day
all
after
trying to
tomorrow,
help him.
yes. Yes, Your Lordship.
My lord, if can be taken tomorrow, then the issue will be resolved on its own.
We are not going to direct the tribunal.
No, I'm because my last
Sir,
date is my
my lord, say as expeditiously as
I
possible.
understand,
It's our
my
responsibility, sir. We
my
should
last
are
date
with
is
you.
21st actually, my lord, and if it will become infructuous.
He has
If
come
I
to
I
court
do not
late.
get my PCC,
Then you should have approached earlier, sir. You have deposited
another
the-
question of law is can
The question
my
of law,
SIR
sir, the question of law is also that on 3rd of June, you have
Taken on
made the
record.
can the
paper, sir,
PCC
doing all
be
these things.
withheld because my SIR is being deleted? That's the moot question, my lord.
Absolutely, his
The question of law is
citizenship
on
is in
3rd of June, he
question.
made the paper, and he is waiting till today.
No, before that also, please.
So you
It
can
was
straight come to
deleted.
the report.
I have explained.
By the present
We are all trying to
petition,
help you.
the petitioner seeks direction, seeks order requesting the Honorable Presiding Officer of the SIR Appellate Tribunal for District of Cooch Behar to dispose of the appeal of the petitioner.
And my lord, one individual, and my father's also, because both are connected.
Say your father is not here, sir.
No, I have appeared
So you should have made your father also. the
because
petitioner.
that will other
That is also a
hinder wise.
technicality.
Your Lordship, it is not possible.
Both are
He has to
linked.
file a
Well,
separate.
page 24 is the page wherein his appeal is
My
there.
lord,
The
PCC
acknowledgement
clearly
of the
said
appeal
if
along
my
with the appeal
father's name
number.
is not restored, I won't be given. If my education is done, my relief won't be, I will be able to obtain.
Let that be done, viewers. Let that be done. We want him to
Appeal.
succeed.
Petitioner appeal number, prayer number 2, dated such and such, and of his father, Farooq Sarkar's appeal being number such and such, dated as expeditiously possible.
Plus one is at page 24, another is page 29. Let both of
The
them be
number
expedited.
is correct. You have
The
checked.
appeal number is there at page 24 and at page 29. At the top right hand corner, the appeal number is there. Let both of them be expedited.
One humble prayer, Your Lordship, a request may be made to the tribunal because it is the tribunal is not subordinate to the Honorable High Court.
Yes, it has been appointed by the Supreme Court in consultation with the Chief Justice of the High Court. So we will request the rest.
These sort of submissions should not be made. I
No, I
aware of
understand
the
that.
fact
Everything is
Honorable Chief
subordinate to
Justice
supervisory
retired Honorable Chief
jurisdiction.
Justice is
My
holding
lord,
as a
my lord.
tribunal.
My
Yes.
lord.
Yes,
So there
that's-
cannot be any direction that is known to the court.
No.
So this
No,
sort of
no, but
submissions-
they should have gone in 227.
Madam is submitting that a request should
That-
be
that
made,
is-
not
that
a
is
My,
not
my lord, my apology. Other benches have made that mistake. That's why I had to pray for it because it is my duty as an officer of a court.
No, please don't do it.
My lord, the Union of India
Possible.
respondent number 1, 2, and 3 is represented.
Okay. So Sudipto Bojumdar. You give your name in the chat box.
Right, my lord. I will do that.
Who is Ikramul Haq and Abjad Hussain?
My lord, this court has adjudicated in similar matters for early hearing based on far lesser grounds.
ठीक है. Expeditious hearing. And also directing respond number 9, Superintendent of Police Cooch Behar, through the District Intelligence Branch and Officer in Charge, Pundibadi Police Station, under his superintendence, to dispose of the petitioner's pending police clearance certificate, in short PCC, application number prayer C, dated 3rd June 2026 on its own merits. Mr. Twainso, learned advocate appearing for the petitioner, submits that the petitioner participated in a recruitment rally for appointment as which is the post
Agniveer.
To be appointed as an Agniveer in the Indian Army. This is
Yes, my lord.
Indian Army. And was declared successful. In order to join such service, the petitioner has to submit a police clearance certificate of with the validity of 6 months. Prior to making application for appearing in the examination, the petitioner submitted police clearance certificate dated
15th of November, 15th of November
15th of November 2025. However, subsequent to the same, since the name of the petitioner has been deleted from the voters list by the operation of SIR, the police is withholding such police withholding to issue police clearance certificate. The deletion from the voter list upon exercise of SIR has no bearing so far as the citizenship is concerned. He relies on the decision of Honorable Supreme Court in Association for Democratic Reform and others versus Election Commission of India and others. Writ petition civil number 640 of 2025. As well as the order dated 24th April 2026 passed by Honorable Supreme Court in Mustari Banu versus Election Commission of India and others. He also seeks for expeditious disposal of the. He further submits that the petitioner and his father, Farooq Sarkar, has already filed a SIR appeal before the appellate tribunal, which is pending adjudication. He seeks for expeditious disposal of the SIR appeal. Mr. Jagriti Misra, learned Assistant Additional Advocate General, submits that until and unless the SIR appeal is decided, the police authority cannot issue such police clearance certificate. Therefore, the appeal before the SIR appellate tribunal needs to be decided at the first instance. He also informs this court that the appeals are being regularly disposed of by the tribunal. Miss ওনার নামটা কি ছিল? অনামিকা পান্ডে।
তোমার সিনিয়র নাম?
অনামিকা পান্ডে, learned advocate appearing for Election Commission of India, submits that the request can be made before the appellate tribunal to dispose of the appeal of the SIR appeal of the petitioner as expeditiously as possible. To buttress her contentions, he relies on the decision of Akul Sheikh versus Election Commission of India, WPA 10421 of 2026. Admittedly, the name of the petitioner and his father has been deleted during SIR process. Against such deletion, appeals have been filed by the petitioner and his father Farooq Sarkar, which is pending before the SIR appellate tribunal.
Page 24 and 29.
24 and 20 number tak te page hai na 24 and 29. Appeal being number such and such. The petitioner has applied for getting the police clearance certificate on 3rd June 2026. It is assured by the learned additional AAG that as soon as such SIR appeal is disposed of, the police clearance certificate would be issued expeditiously.
In accordance with law.
In accordance with law, after proper verification. In view of such submissions, the writ petition being number 928 of 2026 is disposed of, requesting the SIR appellate tribunal to dispose of the appeal of the petitioner being number such and such, dated such and such, and his father's appeal being number such and such, dated such and such, as expeditiously as possible.
My lord, one indulgence, kindly give a time bar like Akul SK's case, because if they pass the 21st threshold, the tribunal decision, my job will be gone. It will become infructuous.
Sir, at the first instance, I have not stated that you go before the tribunal and seek for expeditious hearing.
There is a lot
Lord,
of defect
in
that is there, but still
tribunal,
we are
my lord,
helping.
Expeditious hearing, they are not
No,
allowing
that,
in this
that
manner,
time
my
bound
lord.
cannot be. You approach the court, this order will be
At least
uploaded. Take the
PCC's
order and
time bound decision, my lord.
You take to the notice of the tribunal that these are these
Parties
facts.
will act on the server copy, that can be said.
All parties to act on the server copy of
My
this.
lord,
Yes.
Grateful, my lord.
38. Lordship, I am for the petitioner. Lordship.
এটা কি করে হলো?
Affidavit of service.
What is this matter?
Lordship, matter is a petitioner is a assistant teacher of high school. Lordship. The transfer matter. Lordship.
Transfer.
Lordship. Petitioner appointment 19 December 2013. Lordship. My application has been pending. Lordship, school. Lordship.
Earlier you made an application.
Lordship.
When?
Page 19. Lordship. Annexer P6. Lordship.
No. Prior to that, in Utsosri portal,
Lordship.
when did you make the application?
My application has been pending. Lordship. In school. Lordship. My annexer.
What is the remark? Your
Annexure P5.
application
Lordship. Page
is being
18.
sent back
School.
according
Lordship.
to decision of the managing committee. We should be happy if you get
Lordship, state has not
greater
been served,
school
Lordship.
nearby your home.
No. Solo Jalpaiguri লোকে করে ফেলিলাম।
The earlier application was not considered.
Lordship.
When did you join?
2013 Lordship.
13th.
13 Lordship. An appointment has been confirmed in 2014 Lordship.
14. Primary school or
High school Lordship.
high school?
Yes, Miss.
Yes, Lordship. He has served in the month of April, Lordship, but we have not received the copy because I think it's the old matter. So, Lordship kindly directs him to serve a fresh and keep it tomorrow, Lordship.
Okay. Not today. Give a copy to her.
Not today, only.
Not today.
Give a copy.
Lordship.
Next.
42.
My lord, I am for the petitioner.
What happened to Ethan Royal and applicable petitioner seeks to make supplementary affidavit?
In compliance with the last order, my lord, I'm filing this supplementary affidavit. My lord, from page number 1011, the detectorship is there, and the last annexure from page number 36 on or up to 42, my lord. All the plots, the khatiyan of the same is given, the copy.
Lordship, in this case, Lordship, I am appearing on behalf of the National Highways Authority. Since it's an old matter, Lordship, the state has not got the previous petition copy. Lordship, Lordship kindly directs the petitioner to serve upon the state affairs, Lordship. Because in this case, answering this.
But there was a further direction for the state and the NHAI to submit the report also, my lord, on affidavit.
But
In which
subsequently,
matter?
I inquiring to the matter, Lordship, the state has not received the read petition copy because the earlier advocate has not written the copy, Lordship.
Or you are appearing for both NHAI and state?
No,
No, my lords.
One is appearing for the state, that's why I have given my appearance.
So who is
but
for
I
the
appear
state?
for the,
NHAI, you have received copy?
yes, Lordship. He has sent me, Lordship, through WhatsApp, Lordship, I have received.
Okay.
But
State has not received.
no, Lordship.
So where is your report? NHAI report?
Is because in this case, Lordship, state is the answering respondent. We have deposited the entire compensation to the state government for disbursement.
That may
Now-
be recorded and direction upon the state may be given, my lord, if that is the case.
Lordship, we will file our report, Lordship. At least give us 2 days time, we will file affidavit, Lordship. in that
After 2
regard.
days, my lord, this circuit will not be there anymore, my lord.
Circuit
We'll have
is
to get
there
it to
after
next
all.
circuit.
The month of July, circuit is there.
He is there, it is.
Lordship,
Now, this
just may I
this
suggest
acquisition
one
was
thing,
done in
Lordship?
the year 2016, my lord.
16.
Yes. Then there was the Alipurduar district was not there. After the Jalpaiguri district, it was there, my lord. We have been interacting with the Jalpaiguri district. Then a new district came into existence. We went to Alipurduar district. They said, okay, the files and everything is there with the Jalpaiguri district. So we have been running after
Yes,
the
Lordship.
authorities from
It's
long
true,
time.
Lordship. File has been kept here in Jalpaiguri, Lordship. Lordship, may I suggest one thing? Kindly direct the petitioner to serve a fresh copy upon the state respondent. And in the meantime, respondent authorities, all authorities will file their affidavit, Lordship. State as well as.
State respondent should to the special land acquisition officer or the any person who is there for the state.
Yes, any person who is there for the state, Lordship.
LR officer.
LR office has the copy. I have conducted.
Yeah. Sorry, my lord.
Serve a copy.
it's
Copy
copy.
দিয়েছো কবে মানে it was served earlier. একটা copy LR office. That's it.
It is informed by learned advocate for the state that the copy of the writ petition and its annexures has not been served as yet.
No, my lord, kindly not record that. In all, তুমি serve করেছিলে তো? He has served it, my lord. That might put him.
Is already there.
That might put him in a difficult position, my lord. A fresh service may kindly be directed, my lord.
Seeks that fresh service upon the state authorities be affected so that the report can be filed. Ms. Supriya Singh, learned advocate for NHAI seeks extension of time to file report. 2 weeks. Let such reports be filed by the state as well as NHAI within a period of 2 weeks. Liberty to mention after expiry of the aforementioned period. The supplementary affidavit filed on behalf of the petitioner is taken on record. A supplementary affidavit. So you serve the copy of the writ petition as well as the supplementary affidavit. ওখানে writ petition আর supplementary দুটো দিয়ে দেবেন। আর supplementary affidavit top দিন filed on behalf of the petition in terms of order dated 9th June 2026 is taken on record.
Much obliged.
Lord, I beg to appear on behalf of the petitioner. Petitioner was an assistant teacher of Shaktigarh High School, my lord. Appointed in 1974, retired on 2008, my lord, on attaining the age of superannuation. Thereafter, my lord, the petitioner opted to switch over from CPF to GPF under the my lord, CPF to GPF, my lord, and refunded the employer's share of contribution with interest and with additional interest to the government, my lord. My lord, the option is at page annexure P4 and the
Page number.
My lord.
Thirty-five.
20, my lord, 35 is the option and 36 is the treasury challan, my lord.
36.
36 is the challan, my lord. Thereafter, another PPO was issued, my lord.
14 you have
At page
deposited.
37.
PPF.
Lord, now paying for return of release of arrear pension from the date of retirement till the date of refund, my lord.
Till the date of?
Refund, my lord.
Instruction वाला कुछ नहीं हुआ। हाँ,
Yes.
My lord, on this point, I have a order passed by Justice Rajabashu Chaudhary, my lord.
Yes.
My lord, kindly coordinate bench order, my lord.
No, 49 Arijit.
This is not area.
Yes.
What is? This is change
From
from
the date of retirement till the date of refund, my lord. Not similar, I am praying for similar order, my lord.
Instead of date of refund. Instead of date of refund. From date of refund.
The pension in this case has been released.
Yes, pension is released.
In that case, that was not released. In the case you have referred, pension was released.
Pension was released.
And why there is a direction for issuance of a revised pension?
This is an area, my lord, here I am claiming for area pension, lord.
Is it not to be reduced on it?
The second PPO is at page 37, your lordship.
No, the case was that the pension was given effect from date of refund. In the case you have referred,
Yes.
after deposit, the refund
Lord,
was,
mine is I am paying for Lord, date of retirement till date of refund.
no, the pension has been
Pension has been
released
released
from date following the date of retirement,
from the
but
date
the
of
arrears
refund.
have
my lord.
not been paid.
Yes, arrears have not
So
been.
here is a case where the pension has been given effect from date of refund and not from the date following the date of retirement.
Lord,
So court has directed for issuance of a revised pension payment order.
yes,
Your case is that the date is correct, but the arrears have not been paid.
the arrears have not correct. I stand corrected. my lord.
My-
Judgment.
Judgment to the. My lords, we grant appropriate orders from date of retirement. Instead of date of refund is our direction.
This is not his case. He is
Ah.
claiming arrears from the date
Retirement.
following the date of retirement.
Yes, my lords.
That is his case.
Yes.
उनका judgment भी दीजिए नहीं पर. So he wants in between that. ठीक ही है.
Ask.
My lord, my affidavit of service. And that.
By the present writ petition, the petitioner, affidavit nation, petitioner seeks for release, seeks direction upon the respondent authorities to release and disburse the arrear pension as per PPO, pension payment order. As per the pension payment order, where is it? Pension payment order dated 2nd April 2015. The petitioner contains that he was an assistant teacher of
Shaktigor Vidyapit High School.
Shaktigor Vidyapit HS. Also joined. He was appointed as an assistant on 1st April 1974. The petitioner retired from service on superannuation on 31st December 2008. The pension payment order was issued on 7th January 2009. What are you writing? On 7th January 2009, pension payment order was issued.
Lord,
Pension was granted on 7th January 2009.
yes, my lord.
Then you say that
My lord, earlier PPO was issued.
this pension was without pension. This pension payment order was without pension.
Yes. Thereafter, pension was started, my lord.
So you have not written that?
That is in page 37, your lordship, column 6, pension with effect from 19th of September 2014, your lordship, in page 37, your lordship. Dated 2nd of April 2015, your lordship.
19 September 2014.
Yes, your lordship.
চাই খেয়ে বুঝতে পারছি না। Prayer is wrong, sir.
Not with effect from 2015.
You have to first pray for giving effect of pension from date following the date of retirement. That prayer is not here. Directly you have sought for disbursement of the arrear pension.
Will not allow me to come back now.
You have placed that decision.
Yes.
So at that point of time, you say that the pension has been granted to you from the date following the date of retirement.
Yes.
Correct?
Yes.
After going through the documents, it is found that it has been given effect following the date of refund. On
From the
18
date of refund.
But there is no such prayer for change of that.
Yes, your lord.
Milord,
Do you understand? There is no
Yes.
such prayer that this has not been given effect from the date following
my
the
lord
date of
will direct
retirement.
issue fresh PPO, Milord.
In the body of the writ petition, have you written that this has not been given effect from this period? Vicky? Yes, 9 years. এখান থেকে নাও। করে দিস। September. Where is 7th January 2009 pension payment order, page number?
33, your lordship.
Pension payment order, 7 January 2009, but without any pension. On 18 September 2014, the petitioner opted to switch over from Contributive Provident Fund scheme to GPF, no? Statement. See, the mistake is you say on 18 September you opted to switch over, and on 15 September you refunded the employer's share. How can that?
In 2012, we opted for that, your lordship, from the RDO.
Copy refund. What is the date of refund?
Date of refund is 19 September 14, your lordship.
19 September. The
P
petitioner get it.
536.
The petitioner refunded the employer's share of contributive provident fund in terms of GO 749 AC within bracket A/SL 5A/56/13 within bracket part 5 on 15 September 2014 for switching over from CPF scheme to GPF for the purpose of availing the benefit of pension. The pension has been given effect from 19 September 2014 and not from the date following the date of retirement. Date of retirement আগে বলেছে? বলে দিন date of retirement, হ্যাঁ বললাম না? August 31st August 2008. হ্যাঁ। Being agreed by such action of the state respondents, the petitioner has preferred the present writ petition. Mr. So-and-so, learned advocate for the petitioner, submits that the pension granted in favor of the petitioner has been given effect subsequent to date of refund, but not from the date following the date of retirement of the petitioner. He seeks for appropriate orders. Ms. Esha Acharya, learned advocate for the state.
Your Lordship, from the page 37, it has been given effect from 19th of September 2014, Your Lordship, and as per our direction, the instructions, it says that it can be given from the date of retirement itself, Your Lordship. I'm led by Ms. Radhika Agarwal in this matter, Your Lordship.
Submits that the 31st December, it will be 1st January 2009. Submits that the pension has to be, leaves the matter to the discretion of the court. In view of the above, from the materials on record, it is found that the pension has been given effect from 19th September 2014. 37 2014, that is subsequent to the date of deposit on 15 September 2014. It is settled principles of law that pension should be given effect from the date following the date of retirement. Accordingly, the Director of Pension Provident Fund, respond number এরপরে একটা থাকে দিয়ে দেবেন, এটা ঠিকই আছে। এটা আমার চেঞ্জ রিফান্ডের দেখে হয়তো ডিস্ট্রিক্ট ইন্সপেক্টর অফ স্কুলস হবে এটা মনে হচ্ছে। And Treasury officer is directed to verify the records, and in the event it is found that petitioner exercised the option and refunded the employer's share of contribution within the time specified in notification dated 13 June 2014, then steps shall be taken for issuance of revised pension payment order in favor of the petitioner with effect from date following the date of retirement on superannuation, and to release the pension in accordance with the revised pension order within a period of 8 weeks from date of communication of this order.
Grateful, Your Lordship.
এটা একটা ডিরেকশন থাকবে, এরিয়ার্স এর ডিরেকশন থাকবে, আর ওই পার্টিকুলারলি কে ভেরিফাই করবে ওটা আমার অর্ডার একবার দেখে নেবেন। ডিসপোজ What is this case? And same thing, I'm going to give. What is in the report? You are for? Who is the first wife? You are the first wife.
They have filed a criminal case before the Jalpaiguri CCD. That is pending there. And what they have paid for my son, I just find out.
Which LCR?
They have said that we are the second wife, that is ab initio, whatever marriage is ab initio, it is dependent on declared by way of civil court order by the decree of court. And incidentally, they have asked for the pension which has been in my name. And my marriage certificate, my pension order, everything is in mine.
Then you file a opposition to that, stating the fact that.
We have appeared just first today. Previously, we are not.
What is in the report, Mr. Ghosh?
Second wife, this one number 7, I will include it in all the documents. But the also that she retired in the year 2017. After the death of the husband, they have come out in the program, they have died.
And the other issue which was raised, that whether this writ petition is maintainable before this court or not. What is your submission to that?
I not trying to become this question of law. I not will find what question they have arises in Roman.
No, there was a submission made by. So you are appearing for? You made a submission that whether this is maintainable before this. Oh. Then the administrative tribunal is functional? Not functional. So there is a order passed by the principal bench that till that is functional, the court can entertain such application. So you report, you will be filing in the form of any, or this report can be taken on record. You have given a copy? A report filed by the state respondents is taken on record. Learned advocate, Mr. So-and-so, learned advocate, representing respondent number. You did not appear. This is for the first time you are appearing? Appearing for respond number 7. Denies and disputes the allegations made in the writ petition. He seeks to file affidavit in opposition to the writ petition. Let such affidavit in opposition be filed within a period of 2 weeks. Reply, advance copy be served, reply be filed within a week thereof. Parties are at liberty to mention after expiry of such period. No, you are not filing any opposition to the writ petition. Your report has been taken on record. On a 7 will file. Why you dispute and deny the writ petition? He is an umpire standing alone. If you can succeed, whoever succeeds, he will grant that pension in favor. Next. Martha, what is this? Dio, report to the report. Have you? Which page? Oh.
Mm.
39. Ashun. By the present writ petition, the petitioner seeks for a report filed by the state is taken on record. By the present writ petition, the petitioner seeks permission to deposit/refund the employer's share of contributory provident fund amount together with interest and additional interest in order to avail the benefit of pension. This is petitioner himself.
Yes.
The petitioner contains that she joined as an assistant teacher. She was an headmistress. The petitioner was headmistress of Holy Cross Institute, District Darjeeling. The petitioner retired from service on superannuation on 31st August 2011. The petitioner exercised option under ROPA 1990. In order to avail the benefit of pension, the petitioner intends to deposit/refund the employer's share in the contributory provident fund. Hence this writ petition. Para 4টা সেম হবে, শুধু দেবজিৎ কুন্ডু করে দেবে। এখানে আছে অর্ডার। On the contrary, Mr. Orijit Ghosh, learned advocate for the state, submits that the petitioner has not exercised option as per notification number 749-AC within bracket L/ACL/5S-56/13 Part 5 dated 13 June 2014, 13 June 2014, for switching over to pension cum gratuity scheme within the prescribed period of 3 months. And therefore, the petitioner is not entitled to refund the employer's share in the contributory provident fund amount at this stage. He seeks for dismissal of the writ petition. It is no more res integra that once an option under ROPA 1990 is exercised, the exercise of fresh option all over again is not necessary. Therefore, the contention of the state respondents does not hold good. In line with the earlier decisions, the respondent district inspector is three district inspector schools AC Darjeeling is directed to calculate the employer's share of contributory provident fund with interest and additional interest from the date of superannuation, which the petitioner is required to refund for availing the benefit of pension, and intimate the same to the petitioner within a period of 8 weeks from date of communication of this order. The petitioner shall deposit the specified amount of the employer's share of CPF with interest and additional interest to the government treasury through the concerned district inspector of schools. Stop. The concerned district inspector of schools shall send the pension papers of the petitioner to the respondent number. Director is 4. Respond number 4. Director of Pension Provident Fund and Group Insurance, West Bengal, after verifying the same, and shall issue pension payment order in favor of the petitioner as expeditiously as possible. The pension shall be granted from the date following the date of retirement of the petitioner. Disposed of. বাকিটা ডিরেকশনটা ছিল না, এটা ডিরেকশন দিয়ে দেবেন to serve copy of.
I think 114.
Yes, have you part 3.
No. Yes.
This appears to be the case when the petitioner has very mostly agitated a particular point. That the private respondent loss and all his related loss is already holding one of the FPS licenses. Now, what also appears not from the that has been submitted on behalf of the parties, that was in this case, there is a equal and flag denial on behalf of the respondent as well. He has gone into affidavit and everything saying that there is no relationship. In my humble solution, this appears to be a disputed question of fact. And then there is a disputed question of fact was perhaps interpretation is not the limitation of the program. Doesn't show that limitation. So, in view of the fact that there are some facts that is more than it has to be administered by a different civil court, then the basis can be.
Yes.
My lord, so first of all, the judgment is getting denied by the federal member of the extended court. The background is because of the residence matter. In my case, matter is not regarding the residence. And my learned friend is relying on the judgment matter. They submitted that. One of the membership of a lady has been changed after marriage. Now, my lord, the membership of the throne that can be changed after the marriage. But my lordship can consider my petition is with regard to the relationship. The relationship of a lady with her husband, with her father, or with her brother cannot be changed even after the marriage. The relationship is there. It is in regard to the relation. Lordship, if your lordship kindly see the notifications and the control order, it is only with regard to the relation. The relation is all as it was earlier, it will be after the marriage. After the marriage, the father cannot be changed of the lady or the relations with the brother. So, my lord, this judgment, my lord, is not applicable because it is only with regard to the residential status and the, my lord, both through as well as the status, both through and the, my lord, these are not my case. My case is relation. Relation cannot be changed after the marriage of the lady with her father and the brother. So, my lord, it is, and secondly, lordship, the page 61 has been shown by your lordship, that is in the earlier order of the writ petition. The earlier order 61. Paragraph number 1, 2, 3, 4 has been relied by the learned advocate, my lord, acting for the president. My lord, I'm reading. One second. Upon hearing the parties and upon producing the documents as also record mentioned in the office of the subdivisional controller student supplies Matabama, a gazette order shall be passed and communicated to the all concerned. So, my lord, the earlier order, which is not challenged by the private respondent, where my lord specifically mentioned upon producing the records. So my lord, now your lordship, now your lordship kindly comes to the report which has been filed by the state, by the respondent, my lord, the sub-divisional controller, Madhava. Lordship kindly comes to page 5 of the report. My lord, the memo dated 14/12/2023. In connection with the order passed by Obiji Bangabandhan, the Honorable Justice of High Court Circuit Bench at Jalpaiguri on 13/12/2023, I am submitting a report as to the relation issue in question between Sri Vishnu Pada Adhikari and Kavita Burman. I stated that there is a relation between Vishnu Pada Adhikari and Kavita Burman as part of his record. Now, lordship's kindly comes what is there in the table. Vishnu Pada Adhikari, serial number 4. Okay, no. Thereafter, lordship kindly comes to the table. Serial number 4. Vishnu Pada Adhikari, son of Virishankar Adhikari. Kavita Burman, head of family, Bhavesh Burman. Now, lordship's kindly comes the next part. Further to add, as an investigation is done for collection of some data and information from the RC register of ex-FPS dealer Naimuddin near local resident of Virishankar Adhikari, and wherein it appears Vishnu Pada Adhikari and Kavita Adhikari both are son and daughter of Virishankar Adhikari respectively. A extract of RC register is also attached. Now your lordship's kindly comes to the the ration card, where the first one of ration card of Kavita Adhikari, her husband is Bhavesh Chandra Burman. Second ration card, that is page 7, Vishnu Pada Adhikari, her father is Virishankar Adhikari. Now lordship kindly comes to the, this is very important, that is lordship kindly comes to page 8. This is the folio, this has been collected from the office. Now, lordship, this is the page 8 is illegible. Therefore, page 9 is the type copy given by the respondent in the report, where your lordship will get serial number 7 and 8. Kavita Adhikari, Virishankar Adhikari, daughter. Vishnu Pada Adhikari, Virishankar Adhikari, son. So this has come from the office record on affidavit. So there is no question of this.
Okay. Okay. That's all. By the present writ petition, the petitioner seeks direction upon the respondent authorities and its men and agents to forthwith cancel, rescind and withdraw and or revoke the license of FPS, fair price shop, এটাকে ব্র্যাকেটের বাইরে রাখো, within bracket insert FPS, in respect of 0 gram fragment issued in favor of respondent number 7 in violation of notification dated 2nd December 2021. And also for cancellation of the inquiry report dated 27th April 2023 issued by Subdivisional Controller, Food and Supplies, Mathabhanga, Kuch Bihar, as well as the note sheets dated 30th March 2023 and 3rd May 2023 of the District Controller, Food and Supplies, Kuch Bihar. The petitioner contends that on 12th November 2020, the Office of Subdivisional Controller Food and Supplies Mathabhanga Kuch Bihar issued a vacancy notification dated memo number 736/SCF and S/MTS/2020 inviting applications for filling up vacancies of SPS dealership at Falnapur, Chitmahal, as well as Nolgram fragment under Mathabhanga subdivision, District Kuch Bihar. Pursuant to such vacancy notification, the petitioner applied for the said dealership and submitted the application in Form C along with necessary documents on 22nd November 2021. The petitioner was not granted the dealership, and the FPS dealership license was granted in favor of respondent number 7, Vishnupada Adhikari. But sorry, Bhavesh Barman. What is his name? Bhavesh Barman. Vishnupada Adhikari. The petitioner challenges such grant of license in favor of respondent number 7 precisely on the ground that the near relative of respondent number 7, namely Bhavesh Chandra Barman, who is the brother-in-law, has been granted dealership of granted FPS dealership license. Which contravenes the clause 1 of part 3 of the notification under memo number ta koto bollo? A vacancy notice under memo number 650 SCF and S/MTB/2021 dated 2nd December 2021. In which paragraph this notification has been mentioned? Yes, for para 4. Challenging such grant, the petitioner has preferred the present writ petition. In an earlier round of litigation, the petitioner, being WPA 2884 of 2022, the petitioner raised the similar issue, and upon hearing the parties, the Honorable Court disposed of a coordinate bench of this court disposed of the writ petition on 30th November 2022 with the following direction. Page 13. Pursuant to such order, where is the order? Passed Pursuant to such order, yes, earlier read petition. No, after this order, the order of the state authorities. The subdivisional controller F and S Matha Bhanga respondent number such and such caused inquiry. And submitted its report. On 27th April 2023. Miss Sumon Sehenavis Mondol, learned advocate for the petitioner, submits that as per clause 2XA of West Bengal Public Distribution System Maintenance and Control Order 2013, sister sister, comma, her spouse, son or daughter are included within the definition of relative. The notification dated 2nd December 2021 clearly puts an embargo in issuance of license of FPS dealer or distributor or wholesaler in the name of a person whose relative is holding a license, FPS dealer or distributorship license. The respondent number 7 being the husband of, respondent number 7 again. Stop. A near relative of respondent number 7, namely Bhavesh Chandra Varman, husband of respondent number 7's sister, is holding a PS dealership license. Therefore, the grant in favor of the brother-in-law of respondent number 7, grant in favor of respondent number 7 is in contravention of notification dated 2nd December 2021. She seeks for specific direction upon the which authority is supposed to cancel that? 6. Specific direction upon district controller. No? District controller. District controller. Upon respond number 4, district controller, food and supplies, Kuch Bihar, to forthwith cancel the APS dealership license issued in favor of the respondent number 7. On the contrary, Mr. Himadri Shekhar Chakraborty, learned advocate appearing for respondent number 7, submits that once a Hindu female is married, she becomes the member of the family of the husband, and her ties with the original family severed. Therefore, the grant of license in favor of respondent number 7 cannot be set aside or cancelled since the sister now belongs to her husband's family. The definition of relative as provided under clause 2XA of the Control Order 2013 is not happily drafted. To buttress his contention, he relies on the decision of Honorable Division Bench reported in, Srimati Mousumi Maiti, Das Maiti versus State of West Bengal, reported in 2009, Volume 1, CLJ Calcutta. What is the page number of this? Page number? 615. 615. Mr. Jagriti Misra, sorry, he seeks for dismissal of the writ petition. Mr. Jagriti Misra, learned Assistant Additional Advocate General, submits that the respondent number 7 have disputed his relationship with his sister, with one Kavita Adhikari to be her brother. Stop. Such disputed question of fact cannot be decided in a writ petition. And such question is to be decided before the civil court. Upon hearing the learned advocates for respective parties, the only issue which falls for consideration is whether the grant of license in favor of respondent number 7 is in contravention of the rules provided under Part 3 of Memo number 650 SCF and S/MTB/2021 dated 2nd December 2021. In order to examine the aforesaid issue, it will be profitable to reproduce Part 3 of the notification dated 2nd December 2021. Which this is all 7 clauses are there, or there are other clauses? There are only 7 clauses, or there are more? 7. Okay, it can reproduce. Because upon bare reading of the clause 1 of the said notification, it manifests that a person holding a license of FPS dealer or distributor or wholesaler in his name, or a person whose relative within bracket as per clause 2XA of the WBPDS within bracket M and C order 2013 bracket close already has a PS or distribution or wholesaler license will not be eligible to apply for a license of FPS dealership. Clause 2XA of the WBPDS M and C Control Order 2013 provides the definition of relative as hereunder. এটাকে এখান থেকে নিয়ে নেবে XA para. The aforesaid clause, sorry, the aforesaid in the aforesaid clause 4 of 2XA, it is provided that the definition of relatives includes sister, her spouse, son, or daughter. The petitioner para contains that respondents number 7 is the brother of one Kavita Adhikari, whose husband Bhavesh Chandra Bormon is holding a APS license. That is, the sister's spouse is having a APS dealership license. The reports were called for. No. Pursuant to order passed in WPA 2884 of 2022, an inquiry report was prepared and submitted by the subdivisional officer. Upon going through the dated 27th April 2023, 27th April, upon going through the aforesaid report, it is found that the authority concerned has recorded the statement of respondent number 7, who has denied to have any relationship with Kavita Bormon. In the present writ petition, a report in the form of affidavit is filed by respondent number 6, Subdivisional Control of Food and Supplies, Mathapanga. Question একটা দিয়ে দিন তো। Now it is to be examined whether respondent number 7 has got any relationship with Kavita Bormon. In para 3 of the said report, it has been stated that as per the office record, there is no relationship between Kavita Bormon and private respondent number 7, that is Vishnupada Adhikari. However, the subdivisional officer in its report has stated in para 6 that pursuant to an RTI filed by the petitioner in its office, he inquired the matter and collected data and information from ration card register of ex-fair price shop dealer Niyamuddin Mia near local residence of late Girish Chandra Adhikari, and wherein it appeared that Kavita Bormon and private respondent number 7, Vishnupada Adhikari, are daughter and son of the late Girish Shankar Adhikari. And such information obtained and collected satisfy the query of the said RTI application. In the report filed by the state respondents, in memo number 560 SCF and S/MTB/2023 dated 14 December 2023, it is stated that Vishnupada and Kavita Adhikari both are sons and daughter of Girish Shankar Adhikari. as is evident from the RC register of ex-FPS dealer Niamuddin Mia. Annexure P3 to the report, comma, web bracket, the type copy of which is available at page 9 also shows that Kobita Odhikari and Vishnu Pada Odhikari are sons and daughters of Giri Shankar Odhikari. What is this document of annexure A6 at page? No, handwritten document, page 71. Yes.
Oh, this is the certificate of the contract.
The certificate issued by which Khali, which Gram Panchayat is?
71.
Which Gram Panchayat? Khali Mari, Kholisa Mari Gram Panchayat.
No signature of the lodge. Kindly note.
I have the original one.
Dated, there is a signature.
My first paragraph is no signature.
No, at the end, there is a signature of the Gram Panchayat.
Avedon Kanisha.
Dated 2nd June 2023. Also shows that the name of father of Vishnu Padu and Kobita Bala Bormon Odhikari is Girish Shankar Odhikari. It has been argued on behalf of the state respondents that the relationship is a disputed one. However, in view of the, on the basis of denial made by respondent number 7. However, in view of the aforesaid documents, it is palpable that Kobita Odhikari, Bormon and respondent number 7 Vishnu Padu Odhikari are the daughter and son of Giri Shankar Odhikari. When was the license granted? Since respondent number 7, it is not in dispute that Bhabesh Chandra Bormon is holding a FPS dealership license, who is the brother-in-law of respondent number 7, that is husband of Kobita Odhikari, who is respondent number 7's sister. Such being the position, the grant of license in favor of respondent number 7 contravenes notification clause 1 of part 3 of notification dated 2nd December 2021. Accordingly, respondent number 4, district controller of food and supplies Kuch Bihar is directed to issue order cancelling the. You have given the license number.
The license number you have given the requisition itself.
That is the sister's husband license now.
The license granted to the respondent number 7. Vishnu Adhikari, what is the number? Mr. Chakraborty? APS license granted in favor of respondent number 7. Order cancelling the APS dealership license issued in favor of respondent number 7 in null-gram fragment. In respect of null-gram fragment under Mathavanga subdivision, on which date the license was granted? Mr. Chakraborty, provide the license number. Okay. For cancellation holo?
September 2022.
September 2022.
Page 2 of my affidavit.
Okay. It will be September 20 to give the date.
I'm giving the date.
Okay.
I'm giving it.
22. Within a period of, Mr. Misra, within a period of 4 weeks from date of communication of this order. And he has to make an arrangement so that the PDS system is not affected by this such cancellation. Within a period of 8 weeks, 8 weeks from date of communication of this order, district magistrate, a district controller is further directed to make necessary orders so that the public distribution system is not affected by such cancellation till the vacancy is notified by it. He shall make arrangement for necessary distribution of it till the vacancy is filled up. Disposed of. Which one? No, I require this. You ask your junior to collect it. Or give a copy of that portion, that will suffice. I had a the decision relied upon in Mousumi Supra is contextually distinguishable from the case at hand and is not applicable. ওটা মাঝে ঢুকিয়ে দেবে কারেক্ট করবো এইটাকে রাখুন ওর সাথে Mr. Chakraborty, give that definition only, that will be sufficient. Okay. Okay. No, what do you want? What do you want? No. 20th September 22. What do you want? Why similar order? I have not passed any order. I have passed an order in a CAN application. Why separate writ petition has been filed? Peanut is a part of Vedant, so why do you file a separate writ petition? Okay. Let it come up. There is a order passed in a CAN application in that writ petition. How many days? 15 days was given. You don't know? Where is the copy you have served? Come up after 15 days. The CAN is pending. They have been directed to file an application seeking for that permission to install the staircase. That was the order passed in the Peanuts. So Peanut is a part of Vedant fashion. Take instruction, come back to Passover appeal. Next. Go to the next circuit. Stay on the ground that the petitioner is a single subject teacher which adheres the previous the rule provides that the event. You say that in case of single teacher, this is not maintainable.
Yes.
Beyond the jurisdiction of the circuit bench, Lordship.
Oh,
It
beyond
was
the
heard by once.
Yes, Lordship.
It's the second time litigation, Your Lordship.
why this is beyond the jurisdiction?
Lordship, and that falls under the district of the Birbhum, Lordship.
And the Jalpaiguri is also there.
No, Lordship, this is working with the Birbhum school, Lordship.
No, respond number 5 is Jalpaiguri.
Yes.
5 is Jalpaiguri, Lordship, but the place of present posting is Birbhum, Lordship. So the petitioner should have applied before the principal bench, Lordship. This is as per the rules of circuit bench, Lordship, that Lordship, may I read the rules of Rule 1D? District means the judicial district of the Kuchbihar, Darjeeling, Jalpaiguri, and Kalimpong. Then Rule 4, Lordship, all cases originated in the district shall ordinarily be instituted in the in and decided by the bench by the relevant court according to determination fixed by the Chief Justice. So this case is
If the posting would have been in Jalpaiguri, then it will be this court.
no. See, actually, the place of I called the officer to for setting the instruction. The officer said, because this falls under the jurisdiction of Birbhum, we cannot send the instruction laws. Then I found the circuit bench rules, Lordship. Then it is clear that only 5 districts included in the circuit bench rules of Lordship. Since this is the another district, she should have applied before the principal bench, Lordship, not here, Lordship. Because the petitioner's claim says what the home from the distance is 200 kilometers, Lordship.
So she is seeking
not applied
from,
in Jalpaiguri, Lordship.
she is seeking
Anywhere.
transfer from which district to which district? From Birbhum to?
Birbhum to Jalpaiguri, Your Lordship.
Birbhum to Jalpaiguri, Lordship.
Oh.
Your Lordship, kindly fix it on tomorrow. My senior will apprise the court. Kindly.
Okay.
So, Lordship, the competent authority in this case is the DI of the Birbhum, Lordship. So it is difficult for us to
Tomorrow.
obtain. Yes, Lordship.
Great, Your Lordship. Lordship, I am appearing for the petitioner.
I appear on behalf of ECI, Your Lordship. Lordship, this is a similar matter that was, an order was passed earlier today, item number 37. Lordship, kindly the similar order be passed.
Yes, sir.
Lordship,
Can be passed.
Lordship, here the appeal is pending, my lord, and in spite of possessing passport, my lordship
Go
kindly
to the-
sees page number
Passing the
34.
Similar order or expeditious
All right.
disposal of your appeal, you have given the number
Lordship, appeal number is in 32, page number 32.
32. This is, how many persons are there? How many persons are there?
One person, my
One.
lordship, only one. Page number 32
This is
contains
for
the
early disposal of the SIR appeal. The petitioner, by the present writ petition, your affidavit of service. By the present writ petition, petitioner seeks for requesting respondent number 4. The presiding officer of appellate tribunal constituted for 5 Sitalkuchi SC Assembly constituency to hear the appeal of the petitioner being number APS 2501 prayer dated 4th April 2026 expeditiously. The petitioner contends that his name has been deleted from the roll of the voter list. Challenging the same, the petitioner has already filed an appeal before the SIR appellate tribunal being number such and such, which is pending disposal. The petitioner seeks for expeditious hearing of the said appeal. Learned advocates representing the party, learned advocate for the petitioner seeks that a request be made to the SIR appellate tribunal to take up the matter of the petition, appeal of the petitioner out of turn. Learned advocate for the ECI as well as Union of India submits that, concedes to such submissions in view of the above. The writ petition is disposed of, requesting the SIR appellate tribunal to dispose of the appeal of the petitioner as expeditiously as possible. Disposed of.
Grateful, Your
grateful lord.
My lord, I'm for respondent number 1, 3, and 4, my lord. Although we have instructions to appear, however, we have not received the copy of the petition as of now.
So this is my application.
My lord, I apologize.
This is transfer application. This petitioner is the assistant teacher of a high school, my lord, and he joined us as service in 2007. Subsequently, the service was approved by the district inspector of school, Kujibihar. Now, in the year 2022, he applied the transfer on the spouse medical ground. Kindly see, my lord, page 17, my lord. Page 17, my lord. And my lord,
Page 17.
17 is the
So page 17 is approval.
approval. Thereafter, my lord, kindly see page 20. There are series of medical report. 20 is the certificate issued by the doctor. This is serious sparse ground.
So what is your application?
Application, my lord, kindly see, my lord, page 28. The school issue a no objection certificate. And thereafter, my lord, But he applied online mode before the schools, before the head of the institution, my lord, on 22nd August 2022. Thereafter, my lord, DI took a medical report and DI forwarded the said application before the West Bengal Central School Service Commission. Now, my lord, the application is pending before the Central School Service Commission. Kindly see page 32. This is the status. Well, 32 my lord. DI secondary to West Bengal Central School Service Commission. The application is forwarded. Until date, my lord, the application is not processed, my lord. Whereas, my lord, there is a serious medical ground. I take to them. No, there is a coordinated judgment, my lord. Direct the School Service Commission to consider the application of offline mode.
Mr. Roy is not appearing.
Well, they are said Mr. Sunit Kumar Roy.
You have served upon the.
Yes, I have served, my lord. The item is delivered. Say, Sunit Kumar Roy. Phone করলাম ফোনটা ধরলো না।
Therefore, Mr. Roy is not appearing.
We are representing states.
না, নেই।
কেউ আছে দেখো যে?
School Service Commission কেউ আছে?
Affidavit of service filed on behalf of the petitioner is taken on record by the present writ petition. The petitioner seeks direction upon the respondent authorities to consider the application of the petitioner. 4 years, this is pending.
Yes, my lord. Application is made, my lord, 22nd August 2022.
It was forwarded on which date?
My lord, 14 October 2022. Page 32.
14th October?
Yes.
No, 24. 14th October. Seeks for direction response for to consider the application of the petitioner for general transfer on medical ground dated 22nd August 22 on offline mode. This is from which place to which place? And allow the transfer in favor of the petitioner to the opted / preferred school or to any school nearby the residence of the petitioner. The petitioner contains that he is an assistant teacher in Chaudhuri Har, Vivekananda Vidya Mandir, District Kuch Bihar. The petitioner joined the said school on 17th November 2007 and his service was approved on 31st December 2007 by District Inspector of Schools AC Kuch Bihar. The petitioner's wife is suffering from serious gynecological problems since 2021. On 22nd August 2022, the petitioner made an application seeking transfer on spouse medical ground before the head of the institution. Subsequent thereto, the institution provided the no objection certificate and forwarded the application of the petitioner seeking transfer to the concerned district inspector of schools AC, which in turn forwarded it to the West Bengal Central School Service Commission on 14th October 2022. However, till date, the Commission has not considered the application of the petitioner seeking transfer. The petitioner contends that the Utsosri portal has remained suspended for long. Hence this writ petition. Mr. Devojit Kundu, the advocate for the petitioner, seeks that the matter be relegated to the West Bengal. Respond number
4, my lord.
To consider the application of the petitioner seeking transfer in accordance with law. When the advocate for the state leaves the matter to the discretion of the court. Despite service, none appears on behalf of the West Bengal Central School Service Commission. 1-1. It manifests from annexure P3 at page 32 of the writ petition that the transfer application of the petitioner has been forwarded by the concerned district inspector of schools secondary education to the West Bengal Central School Service Commission on 14th October 2022. Thus, admittedly, the application of the petitioner seeking transfer is pending at the end of the commission. Accordingly, the respondent number not 2, 3, chairman 4. Secretary, West Bengal Central School Service Commission is directed to consider the application of the petitioner seeking transfer dated 22nd August 2022. Within a period of 6 weeks from date of communication of this order. What was the 6 weeks? In accordance with law. Disposed of.
Great, my lord.
No, medical letter DA again.
FDB service, sir. FDB service, FDB service.
55, I'm appearing on behalf of the petitioner, your lordship.
My lord, I'm for respondent number 1, 3, and 4. My lord, we have not received the petition copy as of now. For the bank, my lord. Although
Axis Bank, your lordship, this is my affidavit of service, your lordship. It has reached on 8.
Instruction and as well as the copy of the petition from the bank. Although we have instruction to appeal.
Wait, this is the affidavit of service, your lordship. It has reached on 8th, your lordship, if I'm not wrong.
Did the report come from the concerning respondent's bank?
Yes.
Answering respondent is bank, your lordship. What has happened that the petitioner is involved in trading, and subsequently there has been some transaction because of that, which the petitioner was not aware of. was cited as a cybercrime transaction involving cybercrime, your lordship. And based on that, the entire account of the petitioner has been frozen since the year 2023. He has been to post to pillars, your lordship, with a request, with a prayer to defreeze his account, but that has not been answered yet, your lordship. Subsequently, your lordship, on
He was arrested.
no, your lordship, because he is not an accomplice to any of such transaction or
He is
crime,
an
your lordship.
accused. He is an accused.
No, he is not, your lordship.
Your account is being used by some other person.
Yes, that is, and no information has been given because the petitioner subsequently sent legal notice via the letter dated 5th of March 2026. That is in the annexure B in page 21, your lordship.
No, what is the details of the criminal case?
That has not been given to the petitioner, your lordship. The particulars are not given. Verbally, in some situation, he has been informed, your lordship, but the particulars entirely, it has not been given, your lordship.
Let them come up with a report.
Even
If there
he
is
has
any criminal
not received
proceedings,
any notice, your lordship, from
it
which
has to
he
be examined that whether any such order has been passed by a court where the other accused may be, whether there is any criminal proceedings. You don't know anything, how this has happened. That is your contention.
Yes, your lordship, kindly peruse page 18, the information that we wish to inform you that there is a freeze and lien mark in your account for complaint against you. Acknowledgement number is so and so. Further, we would like to inform you that your complaint is currently with police. We request you to kindly coordinate with
Police.
and he has sent mail to that address also. Nothing has been given to him in particular.
What is the
your
instruction?
lordship.
Criminal proceedings have been initiated.
I don't have any instruction. I need also some time to get the instruction.
Who made the complaint? The bank.
Must have acted on the basis of some instruction, my lord. Bank cannot sumo to freeze the account.
Exactly, lordship, from the cyber police station, Hyderabad.
Affidavit
the
of
bank
service filed on
was
behalf of the petitioner.
in the year
It was upon my-
2023, but the account has been frozen since 2023 and he has not got any notice from the police, your lordship. I have made them party as well, your lordship, and I have served upon them as well, your lordship, but we have not received any reply yet, your lordship, from the legal representation, and they are unrepresented before your lordship as well, your lordship. Like, they are the respondent number 2, your lordship.
One. This one two. This one is going to be Thane. I don't know.
Tamil Nadu. Cybercrime police station.
Cybercrime police station.
Proceeding to beyond jurisdiction.
আমার ব্যাংক অ্যাকাউন্ট এখানে
Proceeding যেখানে initiate হয়েছে।
In a similar case, your lordship, on earlier occasion, the coordinate bench has observed that in a very similar circumstance case, that the respondent bank was directed to freeze only the amount in dispute. In this present case, the amount of dispute is around 1,88,000 rupees, your lordship. Hello, kindly peruse the order dated 27th of April 2026, passed by Honorable Justice Ravi Shankar.
Something has to be brought on record from the side of the bank. You don't know anything. How do you say that this is 1 lakh something odd is required?
Yes, your lordship. So let them file this.
You also don't know that whether there is any criminal proceedings or not. Who is the complainant of this bank? Who lodged the complaint against you?
It has been intimated by the cyber police station, Tirupur City Police Commissionerate, Tamil Nadu, your lordship.
Okay.
Based on that, as per my
Affidavit of service filed on behalf of the petitioner is taken on record. Registered office. All have been served.
but yes, your lordship. Yes, your lordship. I have given my affidavit of service on 8, and in Tamil Nadu it reached on 9.
Petition is taken on record by the present writ petition. The petitioner seeks direction upon the respondent authorities, particularly the respondent number
4 is the branch where the branch manager of the branch where the petitioner has his account lying, your lordship.
4, Axis Bank, Dinhata branch, to defreeze the account of the petitioner. The petitioner contains that he is an account holder, savings bank account holder in Axis Bank, Dinhata branch since 2022, being account number 922020046677348. On 7th May 2023, when the petitioner went to the bank to withdraw some amount, it has come to his knowledge that his account has been frozen at the request of Cyber Crime Police Station of Virudhi Nagar, Tamil Nadu. How many complaints have been lodged?
Your lordship, that is the particulars are not aligned with the petitioner, your lordship, even
So
though.
this is involved. See, Cyber Crime Police Station. This is Bengaluru, then Hyderabad.
Yes, your lordship, from other police station, there has been an NOC given, your lordship. But from Hyderabad, from Tamil Nadu, it is yet to be received, your lordship. And
Cyber Crime Police Station of Virudhi Nagar, Tamil Nadu, East Division, Bengaluru City, Hyderabad and Jaipur. The petitioner tried to made several representations seeking for defreeze the account. However, that was of no avail. A legal notice was sent on 5th March 2026 and 17th March 2026 to the respondent number 4. However, no steps have been taken till date. Hence this writ petition. Mr. Navankur Pal, learned advocate for representing respondent numbers
1, 3 and 4.
1, 3 and 4, seeks accommodation to take instructions. How long? When? Tomorrow? Tomorrow?
By tomorrow, we need the copy of the writ petition also.
I can serve him a soft copy today itself, right now.
A week's time may be given.
Then it's not possible.
There is a specific.
Let such a report
My lord,
be
we have
filed.
to keep this matter
No,
because
no.
since 2023, your
To
lordship, there is a
23, filed in 26.
Seven.
Wait for some time, let the report
A
come.
week's time maybe.
Okay. Within a period of 1 week.
specific-
1 week. List this matter before the next available session.
Grateful.
Yes, lordship, I am for the state lordship.
Writ to your lordship.
Lord, the petitioner before your lordship, my lord, is an unfortunate sister, my lord, whose brothers were subjected to illegal detention. My lord, the brothers of the petitioner, my lord, namely Shamol Rai, Bimal Rai and Shamol Rai. My lord, both of them, my lord, they had some disputes with respect to a land in the district of Alipurduar, my lord, with an advocate. The other side is an advocate practicing in the Alipurduar district court. Now, my lord, using his influence, my lord, he filed a case, my lord, police registered an FIR.
The case was registered under section 329, 223, 351, 324 of the BNS. Lord, the corresponding sections are of IPCR 448, that is trespass, 188, 506 and 430. All the offenses are bailable in nature. Lord, in this, after registration of this case, without serving any notice, Lord, both Bimal Rai and Shamol Rai Lord, were arrested by the police. No 41A notice was given to them. They were simply arrested. They were detained overnight in the police station, and next day they were produced before the learned CJM Alipurduar. Astonishingly, my lord. I take your lordship to the order of the learned CJM, ACJM, sorry, page 31. Lord, I'll read the order. It's annexure P3, page 31. It says the bail application filed by the accused persons, namely Bimal Rai and Shamol Rai, is taken up for hearing. Heard both sides, considering the nature and gravity of the offense, as well as considering the initial stage of investigation, the prayer for bail stands rejected at this stage. Lord, bailable section case, police arrested, detained overnight, produced before the magistrate. Magistrate says, considering the gravity of the offense, the bail stands rejected. Thereafter, Lord, an application for adding few sections were taken up. Today, CDB returned. Today, the IO of this case filed a petition praying for adding section 3032 and 317 to BNS in the existing section of the case. Lord, these two sections are, Lord, section 378 of the IPC and 411. Both of them deal with punishments which are punishable less than 3 years. These two sections were thereafter allowed. Now, Lord, this is the situation where, Lord, a magistrate, a judicial officer, Lord, who is exercising judicial function, Lord, did not even care to ask the investigating officer that whether section 41A was complied in this case or not, whether arrest was necessitated or not. Lord, nothing. Lordship seized the order, not even a speaking order. What is the gravity, Lord? The issue was related to cutting of crops. Lord, in this manner, Lord, these persons were subjected to detention, I would say illegal detention. Even after that, Lord, we had to approach this honorable court, Lord, for bail. This honorable High Court, Lord, granted bail. Lord, even after grant of bail by the honorable High Court, Lord, it took more than 7 to 8 days, Lord, to release this person from the custody due to want of certified copies. Lord, I will take your lordship to the landmark judgment of the Honorable Supreme Court. There is Arnesh Kumar. Lord, we all know that police is an establishment, Lord, since the pre-independence time, Lord, from the British time. Lord, how the police function, police establishment functions, Lord, we all know. That is why, Lord, the judiciary is there to keep a check on the police. Lord, if the police access is not being checked by the court, by the judicial system, Lord, where will the litigants go? Where will the citizens go? Lord, I take your lordship, Lord, to the relevant paragraphs, page 7.2. Page number 8. Lord, found it. It says the law mandates the police officer to state the facts and record the reasons in writing which led him to come to a conclusion covered by any of the provisions aforesaid while making such arrest. The law further requires the police officers to record the reasons in writing for not making the arrest. In pit and court, the police officer before arrest must put a question to himself. Why arrest? Is it really required? What purpose it will serve? What object it will achieve? It is only after these questions are addressed and one or the other conditions as enumerated above is satisfied, the power of arrest needs to be exercised. In fine, before arrest, first the police officers should have reason to believe on the basis of information and material that the accused has committed the offense. Apart from this, the police officer has to satisfy further that the arrest is necessary for one or the more purposes envisaged by subclause A to E of clause 1 of section 41 CRPC. An accused arrested without warrant by the police has the constitutional right under Article 22 clause 2 of the Constitution of India and section 57 CRPC to be produced before the magistrate without unnecessary delay and in no circumstances beyond 24 hours excluding the time necessary for the journey.
During the course of investigation of a case, an accused can be kept in detention beyond a period of 24 hours only when it is authorized by the magistrate in exercise of power under section 167 CRPC. The power to authorize detention is a very solemn function. It affects the liberty and freedom of citizens and needs to be exercised with great care and caution. Our experience tells us that it is not exercised with seriousness it deserves. In many of the cases, detention is authorized in a routine, casual, and cavalier manner. Before a magistrate authorizes detention under section 167 CRPC, he has to be first satisfied that the arrest made is legal and in accordance with law, and all the constitutional rights of the person arrested are satisfied. If the arrest effected by the police officer does not satisfy the requirements of section 41 of the code, magistrate is duty bound not to authorize his further detention and release the accused. In other words, when an accused is produced before the magistrate, the police officer effecting the arrest is required to furnish to the magistrate the facts, reasons, and its conclusions for arrest, and the magistrate in turn is to be satisfied that the condition precedent for arrest under section 41 CRPC has been satisfied, and it is only thereafter that he will authorize the detention of an accused. The magistrate, before authorizing detention, will record his own satisfaction, maybe in brief, but the said satisfaction must reflect from his order. It shall never be based upon the ipse dixit of the police officer. For example, in case the police officer considers the arrest necessary to prevent such person from committing any further offense or for proper investigation of the case or for preventing an accused from tampering with evidence or making inducement, etc., the police officer shall furnish to the magistrate the facts, the reasons, and the materials on the basis of which the police officer had reached its conclusion. Those shall be perused by the magistrate while authorizing the detention, and only after recording his satisfaction in writing that the magistrate will authorize the detention of the accused. Milord, from the order, Counsel Lordship, I'll pause here for a moment. Lordship has seen the order. Milord, not even a single line, Milord, which necessitated the arrest. Whether the arrest was necessary, whether the constitutional safeguards provided to the accused person before arrest is satisfied, nothing was checked by the magistrate, simply an observation considering the gravity of the offense and stage of the investigation, bail is denied. Let us see next paragraph then. In fine, when a suspect is arrested and produced before a magistrate for authorizing detention, the magistrate has to address the question whether specific reasons have been recorded for arrest, and if so, prima facie those reasons are relevant, and secondly, a reasonable conclusion could at all be reached by the police officer that one or the other conditions stated above are attracted. To this limited extent, the magistrate will make a judicial scrutiny. Another provision, that is section 41 of CRPC, aim to avoid unnecessary arrest or threat of arrest looming large on the accused, requires to be vitalized. Section 41A, as inserted by section 6 of the Code of Criminal Procedure Amendment Act, so and so, which is relevant in the context, read as follows. But thereafter, 41A has been extracted. Lord, I'm not reading that. Let us come to para 10, Lord, the next paragraph. We are of the opinion that if the provisions of section 41 CRPC, which authorizes the police officer to arrest an accused without an order from a magistrate and without a warrant, are scrupulously enforced, the wrong committed by the police officers intentionally or unwittingly would be reversed, and the number of cases which come to the court for grant of anticipatory bail will substantially reduce. We would like to emphasize that the practice of mechanically reproducing in the case diary all or most of the reasons contained in section 41 CRPC for effecting arrest be discouraged and discontinued. Our endeavor in this judgment is to ensure that police officers do not arrest the accused unnecessarily and magistrate do not authorize detention casually and mechanically. In order to ensure what we have observed above, we give the following directions. All the state governments to instruct its police officers not to automatically arrest when a case under section 498 IPC is registered, but to satisfy themselves about the necessity for arrest under the parameters laid down above, flowing from section 41 CRPC. All police officers be provided with a checklist containing specified subclauses under section 41(1) B2. The police officer shall forward the checklist duly filled and furnish the reasons and materials which necessitated the arrest while producing the accused before the magistrate for further detention. The magistrate, while authorizing detention of the accused, shall peruse the report furnished by the police officer in terms of the aforesaid, and only after recording its satisfaction, the magistrate will authorize detention. The decision not to arrest an accused be forwarded to the magistrate within 2 weeks from the date of the institution of the case, with a copy to the magistrate, which may be extended by the superintendent of police of the district for the reasons to be recorded in writing. Notice of appearance in terms of section 41A CRPC be served on the accused within 2 weeks from the date of the institution of the case, which may be extended by the superintendent of police of the district for the reasons to be recorded in writing. Well, this is very important. Failure to comply with the directions aforesaid shall, apart from rendering the police officers concerned liable for departmental action, they shall also be liable to be punished for contempt of court, to be instituted before the High Court having territorial jurisdiction. Authorizing detention without recording reasons as aforesaid by the judicial magistrate concerned shall be liable for departmental action by the appropriate High Court. We hasten to add that the directions aforesaid shall not only apply to the cases under section 498A IPC or section 4 of the Dowry Prohibition Act, the case in hand, but also such cases where offences is punishable with imprisonment for a term which may be less than 7 years or which may extend to 7 years, whether with or without fine. So, my lord, this is the Solomon order passed by the Honorable Supreme Court of India, my lord, on 2nd of July 2014. Lord, we are in the year 2026. My lord has seen that the Honorable Supreme Court has passed directions upon the judiciary, my lord, as to how, my lord, the constitutional safeguards of the accused person has to be protected by the magistrate. There are specific directions. And in case of failure by the concerned judicial officers, the High Court has been empowered to initiate action against the magistrate concerned. My lord, under such circumstances, my lord, if still after 12 years of passing of the judgment, my lord, if citizens are being subjected to, my lord, it's such a treatment, my lord, what is the fate? My lord, where are we standing today? Okay. My lord, considering this judgment, my lord, several high courts in such circumstances, my lord, have taken departmental action against the police officers, my lord, against the magistrate concerned. Several actions have been initiated. My lord, the judgment of Arnesh Kumar was also, my lord, subsequently affirmed in Satendra Kumar until, my lord, another landmark judgment, Lordship knows 2022, my lord, where all the parameters of the Arnesh Kumar, my lord, was reiterated, rediscussed, my lord, and said that these provisions, these judicial directions are mandatory to be followed by each and every police officials throughout the country. Yes. My lord, should I cite Satendra Kumar until your lordship is?
Any other?
Yes, my lord, I will be citing few High Court judgments, my lord, where the actions have been taken against the erring officials. Come copy. My lord, this is a Jammu Kashmir judgment, my lord, passed, decided on July 9, 2024.
Yeah, judicial officers service.
ये तो दाओ तो लेखा था citation.
Service
Lord, I take your lordship to section para 13, my lord. Is it
you give the service?
affidavit to service? Service is complete, my lord. Oh, সবাই state respondent. But I don't know whether my learned friends are representing the learned magistrate, because the magistrate is also party. Respondent number 5. ACGM is a party, my lord. We have served upon the office of the ACGM Alipurduar.
5.
Probably, my lord, High Court administration, lawyer from the High Court administration represents them.
High Court or LR?
Probably, my lord, I am not sure. I'm not sure, but since she is a judicial officer, my lord, the state cannot. That is my belief. I don't know, my lord, if they are.
Yes, Lordship, I am appearing on behalf of the respondent number 1 to 4, Lordship. Not the 5.
But our service is coming, my lord, will find that we have.
State is there. So police officer is represented by
Yes,
you.
Lordship.
Who is the arresting officer?
Lord, respondent number 4.
Dilip Kumar Sharkar.
And the officer in charge is also party. He has been served.
Yes, my lord.
You are representing them.
Well, all the
We are
respondents.
concerned with the ACJM.
They are representing 1 to 4.
এসিজে মালিপুর দল হাইকোর্ট অ্যাডমিনিস্ট্রেশন করে কি হাইকোর্ট অ্যাডমিনিস্ট্রেশন না জুডিশিয়াল
Yes, what is
Lordship,
your
may I
submission?
submit?
Well, I have not finished. But I have not finished, but I've just given a judgment.
Yes, what is
But this is a Jammu Kashmir High Court judgment. Recently decided in 2024. But para 13, Lordship will find it in page number 4. But it has also been enjoined by the Supreme Court that notice of appearance in terms of section 41A CRPC shall be served on the accused within 2 weeks from the date of institution of the case, which may be extended by the Superintendent of Police of the district for reasons to be recorded in writing. Failure to comply with the directions as aforesaid shall, apart from rendering the police officers concerned liable for departmental action, also make them liable to be punished for contempt of court to be instituted before the High Court having territorial jurisdiction. Besides, if judicial magistrate concerned authorized detention, such detention should be recorded with reasons, and in the event such detention is made by judicial magistrate concerned without recording reasons, the judicial magistrate shall be liable for departmental action by the appropriate High Court. The Supreme Court has emphasized that the need to avoid indiscriminate arrest and to ensure that arrests are made only when necessary. The Supreme Court observed that no arrest would be made in routine manner and the police officer would not arrest any person without reasonable satisfaction after some investigation. I will come to page para 21 thereafter, my lord. Page number 8. However, in the present case, respondent has not done so. Respondent has teeth to say that if the judgment of the Honorable Supreme Court is to be followed in strict sense, then almost all the officers of the state would be held liable under clause 11.5 of the judgment. It is appropriate to reproduce para 6 of the objections hereunder, that if the judgment of the Honorable Court is to be followed in strict sense, then almost all the officers of the state would be held liable under clause 11.5 of the judgment. The above words of the respondent do not need rocket science to understand, as it shows and reflects that he is least bothered about the court orders. He should have been ashamed to say such words. If those words are taken as the official stand of the department in which he is working, then it reflects and suggests the approach of the department towards the court and the order of the court. When we go through the reply objections of the respondent, it again shows and reflects that respondent has been made to believe that he is not required to comply with the court orders, but to follow his whims and caprices. Instead of initiating proceedings against the respondent, the department has permitted him to do whatever he would like to do. The respondent and the department cannot be permitted to interpret the direction of the courts, the high courts and the Supreme Courts according to their impulses or quirks. All the citizens of India, the government, non-government organizations are no exception thereto, are under strict legal obligation to implement the court orders by word and letter by letter. If respondent or his department is not willing to implement and comply the orders of the court, the High Court and or the Supreme Court, then what will be the future of our children need to be elucidated here. It is made clear here that the respondent was under legal, constitutional and statutory obligation and duty to implement the orders of the court. If he was not inclined to respect the court's order, then he has to face the consequences, which includes the contempt of court, initiation of disciplinary proceedings, and payment of compensation to the petitioner. For all what has been stated above, the respondent is held guilty of non-compliance for the directions contained in Arnish Kumar versus State of Bihar, reported in so and so, and therefore has committed the contempt of the court. Let respondent cause his appearance on the next date of hearing, that is so and so, to show cause and explain as to why he should not be punished for the contempt of court. Apart from this, respondent department, which it was otherwise required to do, shall initiate departmental action against the respondent for violation of the Supreme Court directions. Respondent is also liable to pay compensation. The amount of compensation to be paid by the respondent to petitioner shall be decided and directed on the next date of hearing. So, my lord, this is not one, my lord, I am carrying it is one. Lord, one more, my lord, there are many, my lord, I have gone through judgment, at least 10 of different high courts, my lord, where actions against the erring officials, my lord, have been taken to the tune, my lord, that they have been imprisoned, subjected to simple imprisonment of 30 days. Fine of rupees 25,000 to be paid as compensation to the person, the aggrieved person, and separately departmental action, my lord. So these are the three modes of punishment, my lord, the Honorable High Courts have taken in such instances and cases. My lord, one more I'll be relying. But paragraph 18, page number 12. But it says, as issuance of LOC or NBWs against the petitioners without issuing any notice to them, without giving them an opportunity to prove their bona fides, and without inquiring them, was in violation of the guidelines issued by the Honorable Apex Court. I hold that the respondents had willfully disobeyed the judgment of the Honorable Apex Court, and therefore they are liable to be punished for contempt of court. As the fourth respondent is the investigating officer in crime number so and so, and he deliberately and willfully concealed the representation of the petitioners and not served notice on them and wrongly apprised the magistrate that the petitioners were absconding and wrongly got the NBWs issued against them, he is liable to be punished. As the third respondent was the officer in charge of the police station under whose guidance the investigation was conducted by the fourth respondent, and the second respondent was the forwarding authority of the lookout circular, and the first respondent was the authority who issued the lookout circular against the petitioners, without confirming the fact whether notice under section 41A CRPC was served upon the petitioners in terms of the judgment in Arnesh Kumar's case, Supra, and the said authorities deliberately ignored the emails, WhatsApp messages sent to them by the first petitioner. All the respondents are sentenced to imprisonment for a period of 4 weeks and shall also pay a fine of rupees 2,000 each within a period of 4 weeks. The sentence of imprisonment imposed on the respondents is suspended for a period of 6 weeks, and the petitioners are directed to pay subsistence allowance at the rate of rupees 200 per day to each contemner within 4 weeks. The Commissioner of Police, Hyderabad City and the State of Telangana, represented by its Principal Secretary, Home Department, shall initiate disciplinary action against the respondents for violation of guidelines issued by the Honorable Apex Court in Arnesh Kumar versus State of Bihar. Lord, under such circumstances, my lord, I am before your lordship praying for initiating appropriate action, my lord, against the erring officials as well as the magistrate, my lord, who has denied my bail, my lord, and has subjected me to suffer imprisonment.
See, the learned ACGM which has been made a party, he is not the officer which passed the order.
My lord?
The officer is not the learned ACGM. It is someone else being in charge of the ACGM.
Yes, the concerned judicial officer, my lord, who had
concerned judicial officer, you have to make her or him a party over you.
My lord, if lordship grants me liberty, my lord, I will make her party personally.
It's a person against whom the departmental proceedings or contempt proceedings, whatever, it should be directed against a specific person.
Person, yes, yes.
So if he's a specific officer, her name should be in the respondent list.
My lord, leave may kindly be granted to amend the cost title model. I'll add her a party.
Because if you come to the order of rejection of bail at
page 31.
31.
Yes.
It has been passed by some officer who is in charge of the non ACGM.
Yes, she was a CJM Alipurduar in charge of ACGM Alipurduar.
Oh. Yes, Miss.
Yes, Lordship. Lordship, since I am appearing on behalf of the respondent number 3 and 4, Lordship, my submission would be limited extent about the arrest, Lordship. Police Lordship kindly takes up the judgment of the Arnesh Kumar, Lordship. My learned friend already read the entire judgment, only left a single paragraph, Lordship. That is there in paragraph number 7, Lordship. Section 41, when police may arrest without warrant, Lordship. Any police officer may, without an order from the magistrate and without a warrant, arrest any person. Clause B, Lordship. Against whom a reasonable complaint has been made or credible information has been received or reasonable suspicion exists that he has committed a cognizable offense punishable with the imprisonment for a term which may be less than 7 years or which may be extended to the 7 years, whether or without any fine, if following conditions are satisfied, namely, subsection 2, Lordship, the police officer is satisfied that such arrest is necessary, Lordship. Next paragraph, Lordship, to prevent such person from committing any further offense, Lordship. Lordship, before this complaint, Lordship, the same police station got three earlier complaint, Lordship. Calcutta PS case number 106 of 2025, dated 2nd March 2025 under section 329 of BNS. The next complaint is Calcutta PS case number 365 of 2025, Lordship. And the third complaint was Calcutta case number 464, Lordship, of 2024, Lordship. This is not the first time police has arrested him, Lordship. Before this arrest, Lordship, 3 FIR was lost. He was granted bail, Lordship, but again and again he was committing the same offense. That particular day, Lordship, some mastered plan has ceased from his possession, Lordship, and the accused person are creating law and order issue, Lordship. Then police was bound to arrest them, Lordship, without the notice, Lordship. It is true the notice was not served, but the incidents were happened, Lordship. 3 times of FIR, they got the bail. Again, same incident happened, Lordship. And incredible information and in front of many witnesses, Lordship, the crops have been seized from the possession of this accused person, Lordship. That's why police has arrested them, Lordship, without giving the notice, Lordship. This is not the first time incident that police has not serving the notice, Lordship. Earlier incidents have happened, Lordship. All the 3 cases is pending, Lordship.
How many cases are there?
Previous 3 cases, Lordship.
This you have stated.
First in 2024, second in 2025, and third is July 2025, Lordship. In last 2 years, Lordship, fourth.
Well, kindly see the sections and the complainant, whether it is the same complainant or not. Lord, there are numerous cases between these parties. I already said, Milord, in the very beginning that the other side, Milord, is an advocate practicing in the Alipurduar court. Civil cases are pending in the Alipurduar district court. Milord, we are prevented, Milord, from even representing ourselves in the district court, Milord, so much so that we have to file a civil division for transfer of the case before the Honorable High Court. The Honorable High Court has stayed the proceedings in the civil court. This person, Milord, he's an advocate. Being an advocate, Milord, he is misusing his position so much that he is instituting cases one after another. And police is arresting me in bailable offense. My lord sees that she says that what has been seized from me? Crops, mastered crops. My crops, Milord, which I was growing, that has been seized from me. That is the allegation of theft. Milord, law and order issue from a person, Milord, who are farmers, who are agriculturists, Milord, they cultivate the land, they mustard, Milord, they sell it. Law and order issue. And that too, for that a bailable case has been registered. Why not POTA Act, Milord? Let there be a POTA Act against me. 124 sedition. Why bailable offense then? If I am creating law and order issue?
Yes, Lordship. As per section 41, Lordship, police has the power if there is a law and order issue, arrest without the notice, Lordship. That's why police, after receiving three complaints, has received.
No. Is it so that the Ernest Kumar judgment distinguishes between the two, that if there are bailable offenses one after the other, you arrest without notice?
Lordship, I am not hearing, Lordship.
Does Ernest Kumar decision says that if there are repeated offense,
Yes, Lordship,
You can arrest
section 41 of Ernest Kumar's Lordship kindly sees the
available
paragraph
of-
number 7, Lordship, when police may arrest without warrant, Lordship.
That is why after para 7, all those discussions were made, Mila. The distinction have been made by the Supreme Court in the subsequent paragraphs.
Okay. Ashok. Affidavit of service filed on behalf of the petitioner is taken on record. By the present writ petition, the petitioner seeks for a declaration that the arrest and detention of the petitioner's brothers
Yes, my brothers. Lord, leave may kindly be granted not to amend the cost under
petitioner's brothers in connection with Calcutta Police Station case number 166 of 2026 as illegal, arbitrary and unconstitutional, and also for adequate monetary compensation. Further, directing
High Court कौन है ये ACGM को?
directing for initiation of departmental
हाँ, वही।
proceedings against the erring police officers responsible for illegal arrest and unlawful detention of the brothers of the petitioner. Further directing for appropriate action against the concerned judicial officer in the administrative side of this honorable court. On the prayer of learned advocate for the petitioner, leave is granted to implead the CGM, the officer concerned, judicial officer concerned in the cause title of the writ petition. As added respondent number 6. Mr. Dr. Arjun Chakraborty, learned advocate.
Chaudhary, my lord.
Chaudhary, sorry. Arjun Chaudhary, learned advocate, appearing for the petitioner, submits that the brother of the petitioners were arrested by the police personnel of Calcutta Police Station in a case relating to bailable offense. The brother of the petitioners were produced before the learned ACGM Alipurduar on page 31. Order is 31. On 16 March 2026. However, the bail prayer of the brothers of the petitioner was rejected by the court on the ground of nature and gravity of the offense, without citing any reasons whatsoever. Prior to arrest of the accused persons in the said case, the police authority did not serve any notice under section 41 capital A of the CRPC in terms of the directions issued by the Honorable Supreme Court in Ernest Kumar versus State of Bihar, reported in this quarter.
नहीं जा सकते। बोलो तुम स्टार्ट करो ना, तुम्हारे रिकॉर्ड आ रहे हैं।
2014 volume 3 SCC, volume 8, sorry, 2014 volume 8 SCC 273. The for such dereliction in execution of duties, the Honorable Supreme Court has laid down the guidelines in Ernest Kumar Sutra, which clearly provides for initiation of departmental proceedings as well as the person concerned are liable to contempt of court before the High Court and liable to pay compensation to the persons who are arrested and detained illegally. Orders have been passed by several high courts basing on the observation in Ernest Kumar Sutra. In the present case, the judicial officer concerned failed to take into consideration the directions passed by the Honorable Supreme Court era Ernest Kumar. On the contrary, Ms. Supriya Singh, learned advocate, representing the state respondent, submits that the brothers of the petitioners are habitual offenders against whom several cases were initiated at all are Falakata?
Yes, Lordship.
At Falakata PS. Therefore, in order to maintain the peace and tranquility in the locality, the police authority was constrained to arrest the brothers of the petitioner. This person has been served, the ASI DK Sarkar.
Yes, yes, sir.
Where is that?
But in the applicant of service, totally fine.
176. Yes. Will you be filing a report or any affidavit against the allegations which has been raised against the officer?
Lordship, there is no direction to file report, Lordship. On
Not required.
instruction, I am submitting all this, Lordship.
You are submitting on behalf of the person who has also arrested without, because
Lordship, then we will file affidavit.
if
Lordship.
you say that you are representing all the persons,
Yes, Lordship.
including ASI Dilip Kumar Sarkar,
Yes, Lordship.
and in the event it goes against him, then he is not represented before this court. If it is examined and found that the decision which has been, the direction which has been given in Ernest Kumar has not been followed, it will fall upon ASI DK Sarkar.
Right, Lord.
So are you filing any affidavit on behalf of the state as well as ASI, or ASI will file a separate affidavit
Both.
why he has arrested? Because that should come in record.
No, Lordship, then two separate affidavit is required, Lordship.
Personal capacity ওকে করেছে
কি করবো?
পার্সোনাল ক্যাপাসিটি
একটু দেখি
কি করবো? उसको तो किया है लेकिन वो इसके लिए इन्वेस्टिगेशन ऑफिसर के लिए क्या करें? हम लोग कर सकते हैं फिर उसके लिए? हाँ?
সেপারেট এফিডেভিট পাই
Lordship, but separate Lordship kindly grants us leave to file separate affidavit on behalf of the respondent number 4, Lordship.
State seeks to file affidavit in opposition on behalf of respondent numbers 1, 2, 3 as well as respondent number 4 separately. Let such affidavit in opposition be filed by respondent number 1, 2, 3 and respondent number 4 separately within a period of 2 weeks. 1 week you file your reply, if any.
My lord.
Since it is my understanding that respondent number 5 would not be required, but the officer will be required, which has been added as respondent number 6. So I'm not passing any orders. It has been served, but not passing any order for filing any affidavit by learned ACJ. It should be the officer concerned.
Yes.
You first serve and file the affidavit service on that day.
My lord.
Petitioner is directed to serve the copy of the writ petition and its annexures upon.
My lords, I doubt that under the provision of the writ rules, whether learned additional chief judicial magistrate can be added as a party or not.
The officer is
It has to be done. It has to be done through the High Court administration. The High Court has to be the party.
It's a service which goes through the registrar judicial.
Yes.
If he files any petition, it can go to the officer, but the officer will intimate the High Court that this has been done. The High Court then appoints an advocate.
But in any eventuality, he has to make High Court as a party.
How the High Court will be part?
No, the registrar judicial has to be the party.
No. This is not a any prayer against the administration, High Court administration.
Whatever this learned additional chief judicial magistrate has done, he has done during the course of employment and the nature of employment.
No. If it was something which he has prayed, he has any deficiency of service from the administration of High Court, then the High Court is a party. Suppose he says that the action, the order which has been passed has not been complied with the direction of the Honorable Supreme Court, and the officer concerned is made as a party. What is the High Court is to do? The order from the judicial side goes to the High Court to take whether to issue any departmental proceedings against the officer concerned or not.
As my lordship pleases.
How the High Court, you tell me, I may be wrong. How the High Court administration
is absolutely correct.
How the High Court administration, I will place it tomorrow. I find out from the registry what is the process.
What the issue is, this person, the learned additional chief judicial magistrate, who would he report to? Who is his appointing authority and who would be his disciplinary authority? If at all an order has to be passed by this honorable court, I do not know what the facts and circumstances are. If at all an order has to be passed, then that order has to be complied with. Then in that case, the appointing and the disciplinary authority has to be there.
Just for the purpose of compliance, Lord, the High Court administration is not required to be made a party. Lord, kindly see my prayer, Lord, what I will pray with respect to the judicial officer. Prayer D.
It goes to the administrator.
He has already written administrative side.
Yes.
Then the High Court administration has to be a
Lord,
party.
that the administration need not be made a party.
This prayer cannot be allowed in its present form.
Can be.
No, cannot be. The High Court has to be a party now.
You may make the officer as a party. In the course of the proceedings, it will be seen.
इसके लिए हम लोग कर सकते हैं.
Okay, forget about this case. Suppose the appointing authority is the superintendent of police. Hearing officer is a officer of the PS. the court passes an order that there is an illegal detention, you issue a departmental proceedings against that officer. The superintendent has to be made a party in a proceedings.
My lordship, in my humble understanding, there is a difference between executive and judiciary. For example, I remember instances wherein a particular judge hasn't been following the order of the Supreme Court.
Him or her a party, we'll see afterwards. Serve upon the officer.
But we are praying for an interim order, my lord, with respect to age. The interim order age. Age 19, my lord.
No, not now.
But the present time may kindly be, my lord, the investigation may be taken up from here.
No.
May kindly be transferred to someone else. But
Not
this
now.
person, my lord, against
No.
whom we are alleging-
Without filing of the affidavit, this cannot be decided.
But let then there be a direction that the
Liberty is
interim order
granted to
may
the
be
parties to file a,
Which is,
by the returnable date and file affidavit
Order
of
में
service
कौन सा ये
on the
वाला है?
returnable date. With this
क्या
matter,
गलती है?
liberty is granted to the parties
available section में bill दिया है.
ये तो non
mentioned
available.
after
ये तो बाद में
expiry of the
available है.
aforementioned period.
पहले available था.
Considering
Interim
missing
order can be
documents,
considered, my lord, after at least the
First, the affidavits, let the
yes,
affidavits
let
come.
that observation may kindly be.
Why?
Otherwise, there will be
There I have not
impression, my lord,
decided
that
it.
the
No.
interim order is refused.
No.
But at least I can place it before the next bench, my lord, after affidavits, my lord, then in that event.
I have not decided on any of the aspect. Let the affidavits come. Why should it be taken away? Why should they? State cannot. The officer जो add करो, to add in respondent number 6.
पुलिस की तरफ से हम डालेंगे.
अरे वो तो अभी भी ऐसा ही है ना.
Next.
उसके अगेंस्ट कोई डिसिप्लिनरी
I'm for the petitioner lordship. I'm the.
It is already 4:15. Should I start?
Yes.
It is
If you
already
take very long,
4:15.
then
Should I
don't
start, my
start.
lord?
No, possibly, my lord, all the
I
parties
will
are
not,
have
normally
been
not, I don't.
represented, so I don't think.
All the parties are not
How is
represented.
so?
Because
Kindly
the commission, my lord, is not represented by us.
I have served all. I have
I
served
am
all.
representing the
services
Whether I have
state.
served or not, that is the main thing. Whether represented or not, that is not to be looked into.
My service is complete.
Private মানে এই যে কোন সুখ শেরপা আগেরটা জানি না কি বলে মানে এটা উচ্চারণ কি
You are representing?
State, my lord. I am representing respondent numbers 1, 4, 5, 6, 7, 8. 1 the state,
5, 6, 7, 8.
4 the district magistrate Jalpaiguri, 5 the commissioner of police Siliguri, 6 the another police officer, 7 another police officer, 8 is the block land and land reforms officer Rajganj.
But I am representing the respondent number 9 private respondent, and I have only served yesterday. And the petitioner resides in Darjeeling. He could not forward proper instruction to me and could not execute the Okolesnama yet. I am appearing on instruction.
Or respond number 8.
9.
9. Private respondent.
Who is this private respondent number 9?
But he is a person who has complained about a transaction in 1960.
No, what is his relation with the present writ petition? You just place the facts
No
of the
relation.
case?
I am the subsequent purchaser.
Okay.
Transaction was in 1960.
My lord.
My lord, so what he cannot do directly, my lord, he has tried to do it indirectly. He cannot file a suit today. He has the knowledge of transfer. So that is barred. So that's why he is now taking shelter of National Commission of SC/ST. And the National Commission, without any jurisdiction, my lord, passed an interim order which is cannot pass. This is absolutely without jurisdiction.
Take 160.
Difficulty is I cannot see my lord.
আজ অব্দি ঠিক হয়নি এটা?
দেখো ঠাকুর দেখতে পাচ্ছ।
But I cannot see my lord.
There is a disturbance from the side of the High Court or principal bench. That's why you cannot see me.
So my lord is part of the principal bench. My lord, can you rectify it?
No, I can. Anyway, can you hear me?
I can hear, but my lord knows me. Unless I see my lord, I cannot. My flow will not come.
কেন এটা হচ্ছে না কেন?
Come here to see my lord.
Who is saying so?
Who is commenting? Somebody is commenting. I was there on Monday.
এখন দেখতে পাচ্ছে। এখন দেখতে পাচ্ছে।
I cannot
Mr.
see anybody.
Joyjit Chaudhary is present. He says that he made a request that you come over to the circuit bench.
I went there.
When did you
Monday I
come?
was there. Monday I was
Oh.
there. My lord was busy in chamber with Justice Supratim Bhattacharya, so I cannot meet.
So you have all the information.
Perhaps my lord knows me.
Okay. কি গো দেখা
What to be
যাচ্ছে?
done, my lord, today?